the case, please?
Good morning. I am the Registrar Clerk for this morning. Chief Justice and Justices, all counsel are online. I call the matter of Thubakgale and others and Ekurhuleni Metropolitan Municipality for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Chief Justice, members of the court, I appear together with my learned friend, Mr. Foss, for the applicants in this matter.
Thank you, Mr. Wilson.
Chief Justice, members of the court, I appear on behalf of the municipality together with Ms. Drake and Ms. Pasha.
Thank you, Mr. Georgiades. Mr. Wilson.
Thank you, Chief Justice. With your leave, we'll advance our case under 6 headings. The first deals with the nature of the breaches that have brought the applicants to court and bring them to ask this court to award constitutional damages. The second is the appropriateness of those damages on the facts of this case. The third is the proper approach to the quantification of damages in this case. The fourth, under our fourth heading, we'll deal with the new evidence sought to be tendered by the respondents in this court. Under our fifth heading, we'll deal briefly with the merits of the application for leave to appeal. And finally, we'll take the court through the relief we now seek. So to address the first issue, the nature of the breaches that have brought the applicants to court. Over 20 years ago, the 133 residents of the Winnie Mandela informal settlement who approach this court today applied for and were awarded housing subsidies. They took advantage of the scheme under the National Housing Act and the National Housing Code that then applied, known colloquially as the RDP Housing Subsidy Scheme, to obtain subsidies which were used then to buy a plot of land and to build a house for each of the individual applicants. Now, the respondents in this case, or their predecessors, the municipality, the mayor of Ekurhuleni, the city manager, and the head of housing, were in charge of that process. And instead of doing what the process required and giving the residents the houses that their subsidies entitled them to, the respondents instead allowed these houses to be given to other people who were not entitled to receive them. Now, the court will have noticed that there are a number of skirmishes on the papers about what caused this. One issue is whether the misallocation happened because the respondents' officials took bribes. Another issue is whether it happened because the respondents' housing allocation system was so irrationally unfit for purpose that it ended up erroneously matching several subsidy applicants to the same house. But whatever happened, it is clear, we submit, and it is undisputed by the respondents, that the respondents are responsible for taking the residents' subsidized houses away from them. Many of the applicants ended up registered owners of the houses that they have no prospect of ever occupying. Many other of the residents are still being sent utility bills for services consumed in the houses that they've never occupied and have no practical hope of occupying in future. Now, that misallocation and its consequences is the first breach of the residents' rights of access to adequate housing that we rely on. It is undisputed. There is no dispute before you that it happened and that it was a breach of rights. But what is particularly unfortunate, we submit, about the respondents' approach in this court is that they ask you to ignore the first breach altogether. Their written submissions don't mention it at all. They simply gloss over the fact that what animates this entire case is that the residents' houses were allowed to be unlawfully allocated to those not entitled to receive them. Now, over 3 years ago, the Pretoria High Court, Thupetji presiding, declared this misallocation to be a breach of the residents' rights to housing. Thupetji ordered that the respondent must correct the breach by providing new houses to the residents at Tembisa Extension 25, which is more or less next door to the Winnie Mandela informal settlement where the residents currently live. If not at Tembisa Extension 25, Thupetji ordered that the parties agree on another location by which the houses should be provided by the 31st of December 2018. The Supreme Court of Appeal later extended that date by 6 months, and so the deadline for compliance was the 30th of June 2019, but otherwise left Thupetji's order intact. And in fact, the other aspects of Thupetji's order simply weren't appealed against. Now, Thupetji wrote in the proviso at another agreed location to the order at the residents' request. Because after the better part of 2 decades of struggle to get the respondents to admit the violation of their rights and to correct it, the residents did not respectfully entirely trust the respondents to do what was necessary to provide houses at Tembisa by the court-ordered deadline. The residents thought that the words "or at another agreed location" would protect them in the event that the respondents invented, exaggerated, or simply relied upon administrative or financial problems to excuse themselves from providing houses at the primary location, Tembisa Extension 25. They also thought that the words "or at another agreed location" would insulate them from attempts to move them too far away from their families, from their friends, and from their cultural and economic life. After all, the houses that they'd been deprived of initially were in Tembisa, and it was in or near Tembisa that they wanted to remain. The residents also asked Thupetji for all of the structural and supervisory relief that she granted. They asked for regular reports. They asked for the right to set the matter down again in the event of non-compliance. They asked for the second, third, and fourth respondents, respectively the mayor, the city manager, and the head of human settlements, to be specifically bound to take the necessary steps to give effect to the primary obligation in her order. Now, what has happened since Thupetji's order was actually made is, we respectfully submit, an unhappy confirmation of the residents' worst fears and an abject lesson in the failure of the structural relief she granted. It has not given timeliness or any effect to the residents' constitutional rights. The respondents' conduct since Thupetji's order has shown that they have never had any intention of acknowledging the wrong committed by the apparatus they control. They never had any intention of restoring to the residents what they had taken away, except perhaps in their own manner and on their own timetable. But the problem is that neither the respondents' methods nor their chosen timetables have ever had much regard to what Thupetji's order actually says. The respondents have always, in other words, sought to assert their pre-existing plans to house the entire population of Ekurhuleni as a whole over what the court order says they must do for the residents in this case. We see this from at least 4 features of their conduct. The first is the initial decision to foist flats on the residents, despite the fact that Thupetji's order clearly required land and a house to be provided to each of the residents. Now, we don't have to argue for that proposition. Basonjay confirmed it, and there's no appeal against Basonjay's order. When it became clear to the respondents that this is what Thupetji's order meant, they brought the variation application to change the terms of Thupetji's order because they clearly never had any regard to it. They'd never properly interpreted it. They decided that it meant flats because they had flats. They decided it didn't mean houses because they didn't have houses, the Tembisa Extension 25. The third feature of their conduct, which we submit as telling, is their failure to engage the respondents at all on where, other than Tembisa Extension 25, they would agree to be accommodated when it became clear that flats were the only thing that was going to be provided in Tembisa Extension 25. In other words, what the respondents didn't do is come to the residents and say, well, hang on, we know that Tier 4J's order requires us to give you land and a house. We're not going to do that at 10 BISA extension 25. Where else can we make sure that this order is implemented? Never happened. And the final indication that the respondents' conduct has never really had much regard to Tier 4J's order is the failure to acknowledge that the court order requires them to adjust their plans and budgets to cater for the implementation of the order. The approach throughout has been, this is what we plan to do all along. The plan has been formulated without regard to the text of Tier 4J's order, and there's been an attempt to sort of force the residents into one of the menu of options, whether or not the particular option complies with Tier 4J's order. And even today, over 2 years after Tier 4J granted her order, there's still no budget allocated to ensure compliance with it. And the respondents take quite emphatically that it is the very absence of the budget that they have failed to allocate that might prevent them from complying with Tier 4J's order for many, many years to come. So the result is that today, as we sit here, Tier 4J's order has not been fulfilled. The breaches we've identified have not been corrected. The residents still do not have houses at 10 BISA extension 25 or at any other agreed location. In fact, they have no houses or flats that have been constructed on offer anywhere. There is no prospect of the residents having such houses in the near future. The respondents cannot even name a date by which this is likely in their estimation to happen. The residents still live in their shacks. They live a stone's throw away from the houses that they were allocated over a decade ago, while other people who were never entitled to those houses live in much greater security and comfort than the residents do. The failure to implement Tier 4J's order or to have any serious regard to it is the second breach of the residents' constitutional rights to housing. And insofar as the breach inheres in non-compliance with Tier 4J's order, it too is undisputed. Now, it is against the background of these two breaches that this claim for constitutional damages we submit falls to be determined. A fundamental point we advance today is that given the lengthy and often discouraging history of non-compliance with constitutional and statutory obligations and court orders in this case, we simply run out of remedies. There is only one effective remedy left, and that is the payment of constitutional damages. That is our primary submission, is that is what makes constitutional damages appropriate relief. There is simply nothing else. There's certainly nothing else that will effectively vindicate the rights the residents seek to uphold. Now, following the test in Thupetji, having outlined and established the nature of the breach of rights, we now turn to whether constitutional damages are the appropriate remedy for the two common cause breaches we identify. This court will be familiar with Ekurhulene's decision in Thupetji versus Minister of Safety and Security. It is widely cited and is stock in trade for constitutional lawyers who make cases based on appropriate relief. And Justice Ekurhuleni essentially says two things. The first is you look at the nature of the breach of rights, and then you look at the appropriateness, whether damages are appropriate relief in light of the nature of that breach. So having established the nature of the breach, we turn to whether damages are appropriate relief having regard to the nature of it. Now, we also know from Thupetji that appropriate relief means effective relief. It does not mean, and this we submit as fundamentally important, merely available relief. Our learned friends spend a great deal of time setting out what they say are three theoretically available remedies other than constitutional damages. Three remedies.
Mr. Wilson, the 10 minutes has expired.
Thank you, Chief Justice.
Mr. Wilson? Mr.
Yes,
Wilson,
Justice Mplanta.
the High Court, in refusing the application for constitutional damages, said that this was a case for contempt of court.
Yes.
You've just mentioned that you ran out of remedies. Will you please elaborate on that and explain
Yes.
whether there are any other remedies available to the applicants other than constitutional damages?
Well, the point I was in the process of making is that, first of all, one has to accept that it's not just any available remedy that displaces constitutional damages. The alternative remedy has to be effective. And we would submit at least as effective as constitutional damages would be. So that's the first point. On the point of contempt of court, there's a two-pronged answer. The first is that, of course, the mere fact that contempt is available does not mean that damages are not available. It's a question of effectiveness. Second point is this: we know what the road that will be traveled on a contempt application will be, partially because the applicants have tried it before. The reporting and steering committee parts of the order of Tier 4J were completely disregarded by the respondents. They convened a steering committee for the entire of the Tembisa township. They convened a reporting, they delivered reports that focused on and were delivered to the entire of the Tembisa township. They completely ignored the 133 applicants in this case. And of course, so they disregarded the court order. And that was their answer when they were sued for contempt. And so the application for contempt is always going to be met with administrative and financial hurdles that may or may not bear on willfulness and malefides. We would ask for the mayor, the city manager, and the director of housing to be committed, or a fine in the alternative. A court may or may not decide that the administrative and the financial hurdles that the respondents raise bear on willfulness and malefides. If they don't decide, if the court decides that those administrative and financial hurdles mean that the respondents aren't willful and malafide, then that's the end. We have no contempt relief and we have no houses. But even if the court decides that the respondents are willful and malafide in their violation of the court order, what we then have is an order either committing the respondents or requiring them to pay a fine. The fine goes to the Department of Justice, it doesn't come to the applicants. That may then, as a second step, coerce some form of compliance with the court order. But we're talking about a multi-pronged process fraught with difficulty and uncertainty that is unlikely in our submission on these facts to be effective. We would in fact have to break new ground in the law to demonstrate that administrative and financial hurdles of the nature that the respondents rely on do not negative the presumption of willfulness and malefides that follows on the breach of a court order. But the fundamental point is that although contempt is theoretically available, it's not more effective than constitutional damages. And it does not in any event exclude constitutional damages. Why can't we have both? There is, of course, a period after July 2019 that the court order has gone unsatisfied. No contempt proceeding now brought in future will remedy the fact that the applicants have had vested rights to houses in terms of the court order since the 1st of July 2019, and those rights have been worth nothing. We submit that there must be some recognition of those rights. Contempt of court can't provide that recognition.
Can I just find out something, Mr. Wilson? It's just a follow-up from my sister Mhlandla. Apart from contempt of court proceedings, I'm sure you are aware that this court in Peko made a supervisory order.
Yes.
Should you not have considered that? Because you seem to be saying that your problem with the contempt proceedings or a contempt order is that you, as the applicants, would probably have a problem in terms of proving fault on the part of the municipality. But if you had gone the route of asking a court for a supervisory order, what would a problem have been?
Well, Justice Chika, the first answer to that question is that that's exactly what we did. The order granted by Thupetji was a supervisory order. The paragraph 4 of the order specifically allows the judge to supervise compliance with the order. So,
when there was no compliance, what did you do?
Well, we couldn't do anything because at the point of non-compliance, it was the respondents that went back to court and tried to vary the order. That led to another 2-year delay in determining the variation application. So one of the many egregious features of this case is the respondents' maneuvers every time it looks like they're unlikely to be able to comply. The variation application in this case was brought less than a working day before the deadline for compliance. The deadline for compliance as extended by the Supreme Court of Appeal was the 30th of June, 2019. From memory, that was a Sunday. On the 28th of June, 2019, the variation application was brought. So at the point it looked as though there was going to be non-compliance, the first step was to use the supervisory order to change the terms of the order. So to change the essence of the order, to change what was supposed to be provided. That led to another 2-year delay. Now,
I'm sorry to interrupt you. I'm interested in this point because
yes.
I just want to get it out of my mind.
Yes.
Paragraph 1.3 envisages that the municipality should have delivered written reports to the residents through their attorneys and to the registrar of the court, not more than 3 months from the date of the order and so on and so on. And then we know that you withdrew the contempt proceedings concerning the delivery of the written order and the establishment of the committee and all of that.
Well, we didn't withdraw it.
Yes.
We left it pending.
Yes. Now, my question concerning the supervisory order was not so much about the report and the establishment of the committee, but a supervisory order relating to order 1, the one that concerned the provision of houses at an agreed. Yes.
But that's exactly the point I was trying to make. That obligation came into effect on the 30th of June 2019. And so the right to set the matter down in terms of the supervisory order in the event of non-compliance with that obligation arose on the 30th of June 2019. That right could not be exercised because on the 28th of June 2019, the respondents brought an application to vary the essence of the order, exactly paragraph 1. So paragraph 1 envisages the provision of houses by the 30th of June 2019. On the 28th of June 2019, a variation application was brought to get the court to direct that flats were a decent substitute for houses and would still comply with the order, and to extend the deadline for the provision of houses by a year to the 30th of June 2020. And so, in those circumstances, bringing an application to for further supervisory reliefs and further directives, whatever they might have been, would have been entirely fruitless, because the very meaning of the court order was an issue between the parties and remained an issue between the parties for well over a year thereafter. During that year, as it turned out, as Basonje decided, the applicants all had vested rights to housing. The variation application was dismissed precisely on the basis that it was incompetently brought. The Basonje relied upon the jurisprudence in this court that essentially says, if you want to vary a constitutional obligation, the variation order must be sought and granted before the obligation comes into effect. What Basonje said is that the application for variation was brought, but it wasn't granted before the 30th of June, 2019. And for that reason, the court had no jurisdiction to vary the order at all, whether under section 172 of the Constitution or otherwise. Excuse me. That meant that the rights vested in the applicants by the court order came into effect on the 1st of July, 2019. But they were worthless to us at the time because there was this pending application about what those rights actually were. You have to fast forward 18 months later when Basonje's judgment is handed down, where she says, well, your rights vested from the 1st of July 2019, but unfortunately, I can give no effect to that whatsoever because I'm not going to award constitutional damages. And the point we make is simply this, that certainly in respect of that period, contempt is not going to work because contempt can't make an official comply with an obligation that should have been complied with almost 2 years ago. It's not backward-looking relief effectively. It won't mean that we haven't lived in shacks for the last 2 years, or for 2 years, at least 2 years longer than we should. And of course, none of the supervisory remedies under Tier 4J's order will help either, because the horse has bolted. The period of time that we should have been in houses has already begun to accumulate. And so that's the major difficulty in this case, Justice Cheeky. We asked for a supervisory order, but the supervisory effect of the order was frustrated by the variation application. There's no point seeking supervisory relief to implement an obligation where the person who bears the obligation is disputing its content.
Mr. Wilson, if my sister is finished, Justice Cheeky.
Yes, I'm done, Judge Matthew.
Thank you. I want to raise something. I want to raise something else, Mr. Wilson. There are actually two questions, but I think you've covered the one. That question was whether these remedies can coexist, and of course you said they can. My question really then is, as I see it, there's no principle in our law, because it seems to be that the respondents suggest that in their written submissions. There's no principle in our law that you must first exhaust other remedies, for example, common law, delictual remedies, and so on, before you can turn to Section 38 remedies, in particular constitutional damages. Am I correct? There's no principle in any of the cases that says that.
Justice Majid, you're correct. There's no principle of that nature. What there is a paragraph in MEC for Welfare Eastern Cape versus Carty, where His Lordship Mr. Justice Nugent says one of the things one has regard to in considering the appropriateness of constitutional damages is the availability of alternative remedies.
But I think in that same passage, he also makes clear, Justice Nugent, that is not to say that you must first exhaust the other remedies. It's not a last resort remedy.
That's absolutely correct. You've completed my sentence, Justice Majid. Thank you.
I want to just finally from my side for now raise this hypothesis with you.
Yes.
Because I'm concerned about this question of what is an effective remedy within the meaning of appropriately relief in Section 38. I want to postulate the following hypothesis to you. If there is an open tender today by the respondents to accommodate the residents, all of them, in flats at Tembisa Extension 27, pending the finalization of houses of the size and type to be that they were going to receive to be constructed in Esland Park a few years from now, with clear timelines and with a supervisory order to be supervised by either a special master or this court. What would stand in the way of your clients accepting an offer like that? That is a purely hypothesis. I want to check with you because I want to see what is meant by an effective remedy that would alleviate the burden that the residents are suffering at the moment, which is not adequate housing. What would stand in the way of that?
Yes, well, the open tender, yes, the open tender that you propose, or that you hypothesize, sorry, yes. Justice Madgett.
I'm not proposing, I can't propose anything, I'm just hypothesizing.
That is exactly why I corrected myself. The open tender hypothesized is exactly what has been pursued by the applicant's attorneys with the respondent's attorneys, and there's some discussion of that in the application to introduce new evidence. The short answer is that assuming that there are definite timetables, there is nothing that would stop us from accepting such an open tender. But I want to make two submissions. The first is that on the papers, the flats that would be provided as temporary accommodation wouldn't accommodate all of the occupiers' families. It's on the papers in the application to introduce new evidence, but the flats are simply not big enough to accommodate absolutely all of the applicants' families. And so some of the applicants' families would have to remain in shacks. The houses on open land obviously would be big enough to so accommodate. The second point is this, and that is, that doesn't preclude the award of constitutional damages. Constitutional damages would still be payable from the date, from the 1st of July 2019, the date on which the breach of Tier 4J's order was first committed and started to run. At the rate that we ask for them, 5,000 rand per applicant per month, until the date on which the flats are actually occupied, not the date on which they're tendered, the date on which they're actually occupied. At that point, we submit that the applicants, the quantum of constitutional damages might well change. But the obligation to pay them would not change, because what is required, obviously, is a house and not a flat. So what the flat does is reduce the harm, and of course there must be a concomitant reduction in the quantum of damages so payable. Hypothetically, to your hypothetical, we would hypothesize an 80% reduction in the constitutional damages so payable in that event, in the event that temporary accommodation in flats becomes occupied.
Thank you.
Mr. Wilson.
Does that answer your question, Justice Mitchell?
Yes, thank you.
Mr. Wilson. Mr. Yes, Wilson, I may have misunderstood you. Do the applicants seek constitutional damages for purposes of enforcing T4J's order? I'm not quite sure where the link arises, that if they failed to obey that order, now they are liable for constitutional damages. I just want to understand that.
So the case on constitutional damages is this, that the link is between the breach first committed 15 years ago or so.
But that breach was resolved in the proceedings before T4J, and it led to an order. So
yes, the order wasn't fulfilled.
yes, no, I accept that. The dispute was resolved insofar as the breach of them having no access to adequate housing. It was resolved by Thupetji, and there was an order.
Respectfully, Justice Jafta, we part ways there because the breach wasn't healed by the order. The breach can only be healed by compliance with the order. And that is why we say there are two breaches in this case.
No,
First is,
Mr.
I'm sorry, I interrupted you, Justice Jafta. I
Yes.
shouldn't have done. Please carry on.
Well, help me understand whether the dispute that the parties brought before Thupetji was not resolved and a judgment rendered and an order given, which gave rise to new rights defined in the order. Am I wrong? Because my understanding is this, Section 26(1) does not guarantee one any particular kind of housing. You can't say, I want a freestanding house. The section doesn't guarantee you that. But the order of Thupetji gave your clients a right of access to a specific kind of housing. That's why I want to understand whether your clients are prepared to move out of Thupetji's order and have the matter looked at afresh as if it's a breach of Section 26(1). And my concern is that if we go back there, we might not reach the end of them being entitled to freestanding houses. So I just want to understand, what do they want to do? Do they want to enforce Thupetji's order? And if that is so, can it be enforced by means of constitutional damages? Then I think I've explained my concern.
And I clearly shouldn't have interrupted you, Justice Jafta, because the explanation is illuminating and very, very helpful. The point is simply this. The rights that were violated 15 years ago are not simpliciter rights under Section 26(1) of the Constitution. Section 26(1) of the Constitution is given effect to through the National Housing Code and the Housing Act. The right that was violated was Section 26(1) of the Constitution as given effect to through those instruments. What those instruments give the applicants the right to is exactly a freestanding house on open land. The subsidy application process and the subsidy award process and the construction of houses constitutionally entitled each of the applicants to a house on freestanding land. And it was the failure to follow, and Thupetji says this, it was the failure to follow the laws and policies that the state had adopted to give effect to the Constitution, Section 26(1) of the Constitution, that were breached. And that is a per se breach of Section 26(1) of the Constitution.
Now, as I understand your argument, I haven't looked at the Act and the other instruments. As I understand your argument, the entitlement to a freestanding house is not located in the Constitution, but it is located in the statute. Or am I wrong?
It's located in a statute that gives effect to the Constitution, yes.
Yes, okay. Now, does it mean then that, does that statute apply throughout the country? The statute that says the entitlement to adequate housing in Section 26(1) of the Constitution must be understood to mean that you are entitled to a freestanding house.
What it says is that the right to housing under Section 26(1) of the Constitution is given effect to for citizens and permanent residents through the allocation of a housing subsidy, which is used to build houses according to government specifications. At the time the subsidy was awarded, 15 or so years ago, the specification was the iconic RDP house that we all sort of have at the back of our minds, 24 square meter house on a, I don't know, I think a 250 square meter plot, but I'm subject to correction on that. And so although the Housing Act and the Code in those days didn't say it as simply and as straightforwardly as you just put it, Justice Jafta, what the Housing Act says is this act is meant to give effect to the Constitution. These are the steps that the government is going to take to give effect to Section 26 of the Constitution. One of those steps is the National Housing Subsidy Scheme. The Housing Subsidy Scheme allows people to apply for subsidies, and those subsidies will lead to the construction of a house on these terms and in these specifications. Excuse me, the Housing Code no longer says now what it said then. For example, one of the real problem the real policy problem about choosing between flats and houses is that the Housing Code now allows RDP housing subsidies to be used to construct flats and not houses. It didn't then. The idea of the housing subsidy is that it would lead to land on a house on open land, which is exactly what was built with the subsidy at the time. And so our case is that the first breach of constitutional rights was the deprivation of the house that was constructed in terms of the legislation meant to give effect to the Constitution over 15 years ago. That's why we're so keen on keeping hold and making the case on the basis of that first breach as well. Because it is separate, we submit, and independent from the breach committed when the respondents violated Tier 4J's order. It is it's one of the bases on which Tier 4J's order was interpreted to mean a house and not a flat. Not because that's what the Constitution says. Sorry?
You see, my difficulty now becomes that if the constitutional damages have to be determined on the basis of the current breach, doesn't that give open to the respondents saying, all right, as the governing instruments currently operate, we can offer you a flat?
No, it doesn't. It doesn't lead to that conclusion, and it doesn't lead to that conclusion for two reasons. The first is one has to have regard to the fact of what we were deprived of. We were deprived of a house, not a flat. The second, the second, if I can.
Yes.
Okay. Sorry, Justice Chapman.
Perhaps you would clarify to me why the present breach, because you separating the bridges, the breaches. You say there was an earlier breach which led to the proceedings before T4J and that was resolved. But after that, there were other breaches which are leading up to the claim for constitutional damages. Now, I have difficulty in having the link in respect of constitutional damages to an earlier breach which has been addressed by the order before T4J. I had thought in my mind, and correct me if I'm wrong, I had thought all along the case by your clients is that we were allocated houses for some reason, we didn't get access to those houses. And therefore, we went to court. Thupetji made an order, and that order says you should give us freestanding houses. And therefore, we're entitled to those houses.
Yes.
Which
that is our case, Justice Jafta, but the point is one can't ignore the first breach because it hasn't been resolved. The dispute that arose because of the first breach was resolved by Thupetji's order. The only point we make is that Thupetji's order wasn't effective on its own to cure the breach that happened over 15 years ago. So I think the short answer to your question, Justice Jafta, I'm not sure it'll be a helpful one, is that even though the dispute was determined by Thupetji, the breach the first breach we identified wasn't cured. It was in fact compounded by a second breach, and that was the failure to comply with Thupetji's order. And all we say really is simply this, that when you're considering the appropriateness of relief as damages, one has to have regard to the whole parade of misconduct across 15 years. One doesn't just, as the respondents ask you to do, in fact, simply look at what happened since Thupetji's order was granted. One recognizes that there was a breach over 15 years ago, that Thupetji's order was meant to cure that breach. It resolved a number of disputes about what the nature of that breach was and whether it happened. But it did not ultimately, the order did not ultimately on its own cure the breach because it hasn't been obeyed. The failure to obey that order is itself another breach. That is our case.
But you say that, yes, but the problem now is the failure to obey that order. How does it become a breach for constitutional damages?
Right.
Instead of dealing with the failure to obey the order? The order is there. And I'm not suggesting, Mr. Wilson, that there cannot be damages arising from the disobedience of that order. I'm not saying that.
Yes.
My understanding of the case is that the constitutional damages are not sought as damages arising from the breach or the failure to obey the order. They are sought as damages arising from the failure to afford the applicants the enjoyment of their constitutional rights.
Yes.
So that's where I have difficulty.
And the way you put it, Justice Jafta, is exactly correct. It is not on its own. Well, I suppose what I've been trying to say in a roundabout way is it is not on its own the fact that they have disobeyed a court order. Yes. If it was on its own the fact that they disobeyed a court order, our case would be entirely different.
Okay.
The court order point is really this. Justice Besson was very specific in why she dismissed the variation application. She said that our rights to a house in terms of the court order vested on the 1st of July 2019.
Yes.
And all we say is whether or not the court order exists, those vested rights stand as conceptually separate and independent from it. And they're not being given effect to either. And that's where we locate the second breach. So I perfectly accept the conceptual difficulties that are raised in this case because of the factual complexities and the layers and layers and layers of non-compliance. But you are with respect precisely correct, Justice Jafta. It is the failure to afford the houses 15 years ago, which was the breach that animates this entire litigation. But then one has regard to the fact that there are vested rights that have a different but related source that became vested in the applicants on the 1st of July 2019, and those haven't been given effect to either. There are rights under the statute and rights under the court order. They've both been breached. They're the rights of the same thing, however.
Okay. I think I heard you earlier on in your argument saying that many of the applicants were registered owners of properties.
Yes.
Now, what steps? Because normally if someone is a registered owner of a property and someone else is occupying the property without their authority, red vindicatives, what kind of action is available? What steps did they take, those in whose names properties are registered?
Oh, none. Precisely because the eviction of the occupiers of those houses was not a step that the applicants wished to take. They didn't want to make anybody homeless. And in any event, the eviction applications in these circumstances would be unlikely to succeed unless the municipality provides alternative accommodation to the occupiers of the houses. These are still RDP houses in a very deprived area. The evictions would have led to homelessness. So what the election that those particular applicants made was, well, we don't want to go through the rigmarole of an eviction application. What we want to do is do what the municipality would have to do if we followed either procedure, and that's build some accommodation. And what we want is accommodation for us. And you rightly make the point, Justice Jafta, that a res vindicatio under the PI Act, it wouldn't be a res vindicatio, it would be a PI Act application, would not help the vast majority of the applicants, because the vast majority of the applicants weren't registered as owners. But they were given subsidy approvals, and those subsidy approvals were for occupation of a particular house. So that the system works in a sort of logical step-by-step process. First, you get your subsidy. Your subsidy is used to construct a house. You're given an occupation of the house, and then later you're registered as owner. The order
I'm sorry to interrupt you in that step-by-step. What does it mean that you're allocated a subsidy? Does it mean you have any rights, I suppose, in the amount that constitute the subsidy?
It means you have, it means that you have a right to have the state build you a house for that value. So the mere allocation of the subsidy doesn't lead to a specific right to a specific house. It's only when that subsidy is allocated to a specific piece of land and a house is built on it, that in terms of the statutory scheme, you then become endowed with a right to possession of that house that will ultimately become ownership.
Okay.
And what we plead in excruciating detail in volume 1 of the record is that each of the applicants had at least reached the point where the subsidy had been allocated and the house had been built and they had a personal right to take occupation of it.
Yes.
Some of them had got a bit further than that. Some of them had been registered by the municipality itself as being responsible for the bills, rates and taxes. Some of them had graduated to full ownership. But yes, sorry, Justice Jeff.
Okay, so it seems then we have to separate them into groups for purposes of understanding the appropriateness of constitutional damages. Because it seems to me, one group, the group that have the houses registered in their names, it is simply a question of we rather choose this relief than to go through a process of eviction. We sympathize with those who are already in our houses, even though they occupy them unlawfully. We don't want them to be homeless, and we would rather opt for constitutional damages. Am I right?
Well, the point goes a bit further than that. It goes to the fact that it's overwhelmingly likely that an eviction application would lead to an obligation on the municipality to provide houses. to alternative accommodation of some sort to the people who are currently in occupation of those houses.
If
Why
they are
not
going
skip
to be
that
homeless.
if they're going to be homeless? But I mean, I think if you're looking at Tembisa RDP houses, it's at least likely that there'd be a colorable claim of homelessness. The upshot of it would be that the municipality would be engaged in some way, and there is an election on the part of those few people who were registered as owners of their houses. They didn't want to go through that. They just wanted the process to be followed as it should have been followed.
Okay. And do we know how many of them, those who are registered owners?
I've identified 2 in the heads of argument. I'd have to go through the papers again.
Okay.
The ownership papers have been removed from the record.
Okay.
Because it would have otherwise been about 15 volumes longer. So we can provide that list. I would counsel against separating those people out for the purposes of constitutional damages. However.
I understand, Mr. Wilson, but as a court, we can't close our eyes to facts which are there.
Of course.
We have to look at all facts in determining the appropriateness of constitutional damages, aren't we?
Absolutely, and we've been very frank about the positions that the applicants are in, and the papers before the High Court set out the documents that were put before the High Court are easily capable of disclosing which of the applicants are owners. It is, I would be surprised if it was more than 10. There are 2 identified in the heads, as I say. However, if I can just say this, we're not asking you not to take into account the fact that they became owners. What we're asking you to take into account is all of everything that happened since then, the multiple undertakings that were given. They only found out that they were owners years and years and years after the fact. As I say in the heads of argument, it was Seri's painstaking research over what I know was months and months that ultimately allowed Seri to classify. First of all, to establish each of the applicants had reached the stage that they had a personal right to take occupation of the property, and found the title deeds that were registered in some of the applicants' names. Some of the applicants, it is true, would have been alert to the possibility that they had more than a personal right to possession once they started receiving utility bills. But even then, the utility bills appear to have been received at their shacks and not at the house that they've been allocated. So it wouldn't immediately be clear to them what the status was. One must take into account that there were several years in which the municipality, the national government, the provincial government, the public protector said, no, nothing's gone wrong, everything's fine. And then it was only in the months leading up to 2015, when the application that resulted in the order that Thupetji made, that the proper position in respect of each of the applicants was established on the documents. And these are people living, as you'll understand, Justice Jafta, in informal settlements without necessarily the access to the deeds registries online and the other documentary sources that Seri had access to. Yes. So the big gap between the deprivation, which happened sometime between 1998 and 2005, and the discovery of the deprivation, which was sometime before the application that led to the order of Thupetji in 2015, ought to be taken into account as well, simply because it's quite different to say to someone, well, go and evict that person because they moved into your house yesterday, and go and evict that person because they've come in and developed settled expectations about occupation. May well be that the people who live in these houses think that they're the owners and have settled expectations about being able to stay there. That changes the justice and equity of the thing as well under the PIRE. So it's not as simple as saying these are owners and they're treated differently to non-owners. one must look at all of the facts that led to the discovery of the breach and its nature, respectfully.
Mr. Wilson?
Yeah.
Oh,
yes,
sorry. You may proceed, my brother.
I'm just rounding up, Mr. Wilson. I think speaking for myself, and I think the other members of the court as well, we are keen to have this dispute resolved once and for all, and that your clients get access to get adequate housing as a realization of the aspiration that the Constitution has given them. It seems to me that there may be a way, the hypothesis by Justice Majid might lead us to a finality in this matter. Are you also optimistic?
No, I'm not, Justice Jafter, and I must tell you why. The Justice Majid put to me the possibility of accepting an open tender that moved us into flats at some point in the near future, pending a definite timetable for the provision of houses in terms of the court order at some future date that was specified. That is, in fact, in the application to introduce new evidence, what the respondents say is the content of an agreement in principle reached between the parties. And we say that agreement was never reached because the relevant specificity was never provided. But that too it has been superseded now, because in the latest application to introduce new evidence that should have reached the justices 2 days ago, the respondents now say they can name no date and they have no budget by which houses that comply with Tier 4J's order will be constructed. What they say is that land will be made available at Esalen Park that will be ready for construction to commence in June 2024. That's over 3 years from now. That's land, that's not houses. They also say there is no budget, and they don't know when they're going to get a budget, and obviously if they don't get a budget, they won't provide the houses. They also hem in every undertaking they make with a series of vague conditions. Maybe there'll be delays, maybe there'll be a third wave of COVID, maybe there'll be this, maybe there'll be that. If we're talking about resolving by agreement without the intervention of this court, then I am respectfully but dolefully completely without confidence. This is exactly what Justice Majid hypothesized, is exactly what the applicants were trying to explore. And the entire possibility was torpedoed when the respondents turned around and said two things. First of all, we can't actually tell you when you'll get your houses at Esalen Park now. And secondly said, and we'll promise to give them to you, but we won't accept that there's any cost or penalty to us if we don't. And we absolutely must affirm that if we run out of money or the dog eats our homework, that's fine, that's a good excuse. And that is not a basis on which I can advise my attorney or my attorney can advise the applicants to settle. And Justice Jaffer, you'll obviously recognize that.
My understanding, I'm sorry, my understanding was that the court would intervene if the hypothesis can work. The court would intervene. And I understood the debate that you had with Justice Chikli to be based on that you would have a supervisory order that will take care of what should happen at what stage and so on. I didn't mean that the parties should be left to their devices in dealing with this matter. They have not resolved it in many, many years.
I respectfully, Justice Jafter, that is something this court has said to me before, and I just wanted to make sure that we could expect the court's supervision rather than an order to go away and talk again. The supervisory order it would be absolutely welcome What we do say, however, is that there is a period of time in respect of which, up until today, the constitutional damages, if appropriate, are payable. And there will be a period of time in future, up until today, after today, that constitutional damages, if appropriate, will be payable. And as I put it to Justice Majid, it's once we move in to the temporary accommodation proposed on his hypothesis, that the quantum of those damages might reduce. And it's only once we move into the houses required by Tier 4J's order that the obligation to pay the damages would be extinguished. So as part of that supervisory order, we would be absolutely, accept that there be an obligation to pay constitutional damages, that there be that obligation subsists for so long as we're out of any type of housing, and then the quantum be reduced once we're in flats. That to the extent that there's any difficulty in determining the reduction once we take occupation of flats, that is certainly, this is sort of biting into the rest of my argument, but that is certainly something that an external referee or this court exercising its supervisory jurisdiction, or the High Court exercising its supervisory jurisdiction could determine the quantum of damages payable once we've moved into flats. All of this is music to the applicant's ears, Justice Jafta. But I don't want to lose, because of the nature of the respondent's case, I don't want to lose sight of the fact that the supervisory order, if it is granted, ought to be in addition to an appropriate award of constitutional damages, not instead of it.
Thank you.
Thank you, Justice Jafta.
When considering an appropriate, firstly, whether an appropriate award of constitutional damages should be made in this matter, should we take into account what this court said in Fosse? And the reason this occupies my mind is that it seems that one of the challenges the municipality has is budgetary problems or financial restrictions. And in Fosse, this court did say that when a court awards constitutional damages, or one of the considerations that are relevant now, I'm now looking at paragraph 73 of Fosse, is the impact those constitutional damages or the award would have on the public purse. And when I looked at this and I was thinking that if for instance, the respondents have calculated and said that according to their estimate, if they were to award constitutional damages, it would be in the region of about 15 million. And when you think of 15 million, that would then be expanded to about 133 people. And you then weigh that against the interests of the other people who do not have housing in the municipality and perhaps other resources as well. And I wondered, because you keep on saying that, well, whatever solution this court comes up with, even if it's to try and sort of bring the parties closer together, you still insist on the constitutional damages. Then this is why I have this question that when you insist on the constitutional damages, have you thought of what was said in Fosse, or should we take what was into account what was said in Fosse? Because we may be solving this case or this matter and then creating problems, in terms of your clients being able to finally get a permanent accommodation in the future.
Well, if I can start with where you ended, Justice Cheeky, there is no case on the papers that that the payment of constitutional damages to the applicants would endanger the provision of housing or other essential services to anyone else. We're talking about a multi-billion rand institution of state. And at worst, according to the respondents, a payment of 15 million rand distributed amongst 133 people. If the respondents were to say, well, look, here's our budget, here are our figures, here is the situation we're in. We actually can't pay these damages without taking away water from someone down the street. That would be one thing, but they don't make that case at all. They do the calculation, they shove 15 million rand in their heads of argument, and they hope to create a sense of scandal and panic on the bench, which I know the bench will resist. The point is that you can only do that exercise, which you absolutely should do with respect, Justice Cheeky, if the municipality gives you the facts necessary to do it, and they don't. All they do is raise a hue and cry about the quantum and do nothing else. So that's the first point. It's an exercise you absolutely have to do, Justice Cheeky. It would not behoove me to say that you shouldn't. But unfortunately, you haven't been given the facts to do that exercise. And just on the probabilities, it's highly unlikely that a massive urban organ of state municipality with a substantial rates base is going to be choosing between providing housing for other people and paying constitutional damages to 133 people against whom it's committed egregious wrongs for well over a decade. And the facts don't take us, the facts really don't take us any further. They might have to choose between non-essential things like parties, cars, lunches, pens, whatever else, and pens are quite essential, I have to concede, but parties, cars, and other things, and payment of damages. But that's what the budgetary process is for. And what this case shows more than anything else is the respondents have abjectly failed to budget for the obligations under this court order. And what you would be doing if you denied us constitutional damages is you would be saying that was okay. They didn't budget to provide us housing from the 1st of July 2019. That would have cost them money if they'd have planned and budgeted to do that. But that's okay. They don't have to pay that money out anymore. What you would be doing is rewarding the failure to budget, the recalcitrance, the failure to organize, to give effect to the court order from the date on which it came into effect. And that raises substantial, we submit, rule of law issues. If you send the message in this court that an organ of state will be rewarded for dragging its feet as long as the respondents have, the effect, the policy impact, which is what I understand Justice Cheeky you to be referring to, would be to tell organs of state that that conduct will be rewarded. They can sit back, they can do nothing, they can fail to plan, they can fail to budget, and they'll defer their obligations 2, 3, 4 years into the future. So that, on a policy level, we submit, Justice Cheeky, would be inappropriate. I also want to...
Mr. Wilson,
yes.
On the flip side, is a quantum of 5,000 per household per month justified or properly established?
Well, those with respect, Justice and Planter, are two separate questions. I was just about to make a further submission to Justice Cheeky. May I make that submission and then turn to your question, Justice and Planter? Because if I don't, I won't fully answer Justice Cheeky's question. Is that okay, Justice and Planter? Thank you. So the second thing I was going to say is that those remarks, Justice Cheeky, I believe were made in the context of suggesting that punitive constitutional damages were inappropriate. Now, of course, this case is not about punitive constitutional damages. The respondents try to tell you that it is, but it just isn't. Punitive damages arise where compensatory damages have already been paid. It's just obvious. It follows like night follows day. And in this case, of course, compensatory damages have not been paid. And so whatever you award will not be punitive. Now, the respondents sort of half-heartedly accept this in their heads of argument, and they say, well, the money that we have to pay will be inherently punitive. There'll be some financial punitiveness. And there, I understand them to be alluding to what you put to me, Justice Cheeky. And of course, the answer to that question is, well, show us that it would be punitive. Set out on the documents that you can't afford this, or you can only afford this by taking money away from other people. They simply haven't done that. The final submission I'd make in response to Justice Cheeky's question is this. One should also have regard to the decision of this court in Blue Moonlight, where the budgetary obligation was given contempt. And there, Justice van der Westhuizen, in I think it was paragraph 74, said, I think it's referred to in our heads as well, said, it's not an excuse to rely on budgetary scarcity. If you have been in a position to plan and budget to give effect to an obligation for years and years before the obligation is meant to be enforced, their budgetary defenses simply cannot be admitted. It's exactly the case here with respect. Since Justice Tearfall's order was handed down, there have been at least 2, maybe 3 budgetary cycles. There is nothing on the papers that shows you that anybody amongst the respondents applied their mind to Thupetji's order, budgeted and planned to give effect to it. Now they say they don't have the budget. Well, of course they don't have the budget, because they decided that they didn't have to plan and budget for it. And that is precisely the point that Justice van Westhuizen makes in Blue Moonlight. And one ought to have regard to it when assessing the budgetary and financially punitive defense that the respondents raise, we say with respect, Justice Cheeky. Justice Mhlantla, you asked me about the calculation and appropriateness of the quantum. Now, the basis for quantification of constitutional damages is an exercise that is far from actuarial. Our submission is simply that a sufficiently close link needs to be established between the nature of the breach and the quantum of damages asked for. Now, the difficulty, and we say that link has been established on the papers. I'll take you to how it has in a moment, Justice Mhlantla. But first, I just want to refer to Justice Nugent's decision in MEC versus Carty, because paragraph 33 of that decision really encapsulates the difficulty courts face when trying to characterize how damages which sounded money and are financial in nature can reflect the breach of a constitutional right, which is ultimately a moral and value-laden phenomenon. And at paragraph 33 of his decision, Justice Nugent said this, and it's an extremely famous passage, I imagine we've all heard it before. To be held in poverty is a cursed condition, quite apart from the physical discomfort of deprivation. It reduces a human in his or her human dignity. The inevitable result of being unlawfully deprived of a grant that is required for daily sustenance is the unnecessary further endurance of that condition for so long as the unlawfulness continues. That is the true nature of the loss that Carty suffered. Counsel for Carty submitted that in the absence of such a measure, she should be awarded an amount equivalent to the interest that is recognized by law, to be payable when money is unlawfully withheld. Counsel for the appellant was unable to suggest a more appropriate measure, and I think we ought to adopt it. Justice Nugent also said in Carty that there really is no financial metric that gives proper effect or properly reflects the phenomenon of being held in poverty. There's no easy actuarial calculation. It's a value-based inquiry. And we rely on Carty to say that's exactly the case in this matter. We have been in shacks for years and years and years when we should have been in houses. It's not just a question of patrimonial loss in the way that Justice Besson said it was. It's every day waking up cold. It's every day having to walk to the tap to pour out cold water to wash. It's every day having to buy the paraffin. It's every day walking past the house you were supposed to be given 10 years ago and seeing how comfortable people are in there. And it's a million other minor indignities, frustrations and resentments. That's the breach of the constitutional right in this case. Now,
Yeah.
one has to, sorry, Justice Malone.
Yes, Mr. Wilson. I guess my question in a sense relates to the issues that Justice Jafta was raising with, my brother Justice Jafta was raising with you. I'm interested to know how, in your view, appropriate relief in Section 38 sits with or dovetails with just an equitable remedy under Section 172(1)(b). Perhaps let me explain how this arises in my mind. I'm thinking, say we are with you that there has been, and indeed for as long as Justice Tifo's, or rather T4J's order stands, that just has to be the position, I guess, that there has been a denial of the constitutional right of access to adequate housing. So we also come to that same conclusion, as I think we must. And then your clients are asking for constitutional damages. And does it not arise that we may then say, once we are there, aren't we also in the realm of Section 172(1)(b), in which event we then consider what an appropriate remedy should be? And if we are in that realm, that, to my mind, is a very wide concept, which perhaps should not necessarily mean constitutional damages. So I just want to understand, with that in mind, how appropriate remedy under 38, how it works with 172(1)(b).
Justice Madlanger, there's nothing in our argument that requires us to distinguish between those two things or to suggest that they can't, that the just and equitable discretion can't intertwine, dovetail, be the same as the appropriate relief test in terms of Section 38. Of course, you have the discretion to grant us any relief that you want to grant us. And if you were to ultimately decide that constitutional damages aren't the appropriate relief and there's some other order that can be made that would be more effective, then I'm not going to tell you that you're not empowered to do it. What I am going to tell you is that you shouldn't exclude constitutional damages for at least the following reason. And that is, there was a court order that vested rights in 133 of the applicants from the 1st of July 2019. The vested rights were rights to a house. On the 1st of July 2019, those houses should have been moved into. They weren't. There is nothing this court can do to turn back the clock. Nothing. Except award damages. If the, and those vested rights will continue to be breached, they won't be given effect to, there'll be a dead letter until we get the houses. We don't know when we're going to get the houses. There may well be an order that this court grants that means that we get the houses a lot sooner than the never, never the respondents currently promise. But every day from the 1st of July until that happens is a violation of the Constitution, of the Housing Code and the Housing Act, and of the vested rights in the court order. And the appropriateness of constitutional damages arises from the fact that those rights have to mean something, and they have to mean something from the date on which they were vested. And that's really our point on constitutional damages. If you were to say, well, constitutional damages are not appropriate because here's some other supervisory order which may be more effective than everything that was tried before. Fine, that might help us in future. But what it won't do is vindicate the rule of law, the courts, the applicants, the Constitution for every day since the 1st of July 2019, the applicant's rights have been vested. And you must, we say with respect, do something that sends the message to the applicants. Sorry, it sends the message to the world, to the country at large, that says, you know, those were violations of rights too. I can't think of anything other than the payment of an amount of money. Now, the applicants don't come to court to become litigation millionaires. They come to court to primarily to get their houses and to be compensated for the period during which they didn't have their houses. The reason why, I mean, it's a bit rich, really. The reason why the amounts quoted in the heads are so high is because the respondents have delayed so long. 5,000 Rand per person per day, per month, per applicant per month didn't seem that much when we wrote the notice of motion, but we wrote the notice of motion years ago. And so it's really quite odd that the respondents say, oh, well, now it's too much money, it's inappropriate. But it's too much money and inappropriate precisely because of the delay they've committed. All we say is that constitutional damages in some quantum, and I'm going to get to the quantum, Justice Inflanter, in response to your question. But all we say is constitutional damages in some quantum must be awarded for the previous disobedience of the court order and the disregard of the rights that vested under it. That's what we say. Now, of course, you may decide that precisely because of the delay and the escalation of the damages, that the amounts as calculated as they were set out in the notice of motion will ultimately result in an amount that is inappropriate. That's different. That's something very different from saying constitutional damages are not in and of themselves appropriate. We submit that they are in and of themselves appropriate because they're the only thing that can grant any recognition to the past violation of rights that's taken place in this case. I want, if I can, just at this point, because it seems most convenient to do so, to address.
Before you do, Mr. Wilson, let me move on to a different point altogether. Is my understanding correct that your clients have no problem at all with taking occupation of freestanding houses in SLN Park?
That is absolutely what they want.
Is it so that the square meterage of those houses is 40 square meters?
I believe so.
Is it so that the square meterage of the apartments is 40 square meters each?
Yes. Can I answer the question that I know is coming?
No, let me ask it. Let me ask that question.
It's probably best that I let you, Justice Mlanga, sorry.
In response to my brother, Justice Majid, and indeed even in your client's letter of, is it 17 December? Yes, I think 17 December 2020. Yes. So two things, your response to my brother, Justice Majid, and what the applicant's attorney is saying in that letter. The point is made that we can't take up occupation in the apartments or in response to Justice Majid, you said, no, my clients can't take up occupation in the apartments because some members of the families cannot be accommodated in the apartments because of the size of the apartments. In the letter, the point about some members of the family not being accommodated is made in a slightly different context, but the point is the same. Some members of families cannot be accommodated. They the context of the applicants saying, no, 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 no. In the interim, we disagree that our informal structures should be demolished. But the point is, we can't occupy. Now I have difficulty understanding that if the houses in Excellent Park to which the applicants are prepared to move are 40 square meters, the apartments are 40 square meters, and the clients are prepared to go to Excellent Park. So that can only be on the basis that they think somehow everybody in the family can be accommodated in Excellent Park.
Yes, because there's land around the houses. I mean, that's the short answer. The houses are on a specified plot of land, and to the extent that the families won't fit into the 40 square meters, the houses will be improved to allow people to occupy additional rooms. I mean, it happens all the time. So, sorry, Justice Madlanger, you're muted.
Oh, can you tell me what the square meterage of the informal structures is?
The informal structures that are currently occupied by each of our clients, no.
But if this point is being raised seriously in the context of very serious engagement, yes, I know the history which you have detailed.
Yes.
And correctly so, with regard to what the municipality has done and has failed to do. You've made very valid points in that regard. But now, from at least, I will not refer far back, I will refer only to about late 2020. Attempts are being made at resolving all of these, and part of that is, let us accommodate the applicants in these apartments. And I know this is not enough for our client to accommodate everybody. Shouldn't we at least be given an idea in that serious back and forth engagement, an idea of what the size of the informal structures is?
Yes, so the second, sorry, I should have started with this point. We have no difficulty in moving into flats. I mean, absolutely no problem. It was actually our proposal. We said, you obviously have flats. We're living in dire poverty in shacks. Flats are better than shacks. And as long as they're only a temporary expedient, we'll move into them when they're
I would not have asked this at all if you had not given the response that you gave to my brother, Justice Majid. You said not because of the problem that not everybody can be accommodated in the flats.
Well, no, so, I'm sorry if I was misunderstood. Sorry
to interrupt. I understand the different context which relates to the non-demolition. That I understand. But as I misunderstood you, I thought you said to Justice Majid, my brother Justice Majid, no, not going to flats because not everybody will be accommodated. Maybe
no, not at all. Not at all. That is not our position at all. And I'm sorry if I allowed myself to be misunderstood. It's probably worth emphasizing again, the idea that we be given flats as temporary accommodation was our idea. It was something floated by our attorney in response, it's on the papers. It was something floated by our attorney in response to, I don't know if it was the first or the second application to introduce new evidence. And so the acceptance of something as an interim arrangement was certainly something we were prepared to do. All we do is we point out that that has consequences. And one of the consequences is that not everybody can fit in to the flats, whereas everybody would be able to fit into the houses on land. The consequences I was trying to point out to Justice Majid is that it wouldn't completely terminate the violation of the right of access to adequate housing, because some people would be left in shacks. And of course, it wouldn't fulfill the terms of the court order because it would be interim. And it was on that basis I was suggesting that constitutional damages should still be payable during the period in which we were in flats. So thank you for giving me the opportunity to clarify myself, because if
my apologies for misunderstanding you, Mr. Wilson. Yeah.
Not at all.
Mr. Wilson?
Justice Turon, I'm backed up. There are answers to Justice Mhlantla I've not yet given. There's another answer to Justice Madlanga that I just want to give. I am not going to queue up judges of the Constitutional Court as if I'm in charge.
Please continue, Mr. Wilson.
Thank you, Justice Turon, but thank you. The point you make about should there not be a, Justice Mhlantla, about should there not be a proper tabulation of how many people are living in these shacks, how big they are, all the rest of it. Well, yes, of course there should be. And of course it's relevant to the determination of how to give effect to the court order. But the difficulty is that all of these things were happening at the last minute. And these problems that arise in negotiations coming up to the Constitutional Court hearing have to be given as head notes. So you don't always get chapter and verse on how each of the individual applicants fit in and what the individual situation is applicable to them. Now, I know I'm going to sound like a broken record, but that's exactly what should have been done from the moment Tier 4J's order was made. It must be the first step. The municipality should have gone in to the informal settlement and established all of these things as part of its planning and budgeting to give effect to the order. And the fact that that didn't happen is precisely aggravating one of the many aggravating features of this case, which we submit means that at least some portion of constitutional damages is payable. So agreement on all counts, but it's happening far, far too late in order to suggest that there's any compliance with the order or any absolution from the obligation to pay damages. Justice Mhlantla, a while ago, you asked a question about quantification, and I want to get back to it, if I may. And I started by a reference to Carty, where Justice Nugent effectively says, you're being held in poverty, it's a multi-dimensional moral wrong, and we've got to find some way of linking an amount of money to this multi-dimensional moral wrong. In that case, in the absence of a financial measure that can adequately reflect being held in the cursed condition of poverty, counsel for Ms. Carty said that she should be awarded an amount equivalent in the interest that's recognized in law to be payable when debts are overdue. There was a link, in other words, drawn between the nature of the violation and the calculation of the damages. And that's what has to happen. A conceptual, morally appropriate, value-based link between the nature of the violation and the calculation of the damages has to be drawn. And we know in Carty it came from the bar. The bar is now suggesting an appropriate, as counsel for the applicants, I'm now suggesting an appropriate, sufficiently close link between us the applicants being held in shacks for so many years, even in the face of a court order that vested the rights to a house in addition to the right we have in terms of a Housing Act. Those violations of rights must be linked to some number. The number we came up with on the papers was what it would cost the applicants if they had to go and house themselves on the open market. They don't have to go and house, they can't actually go and house themselves on the open market, and they shouldn't have to. That's what the Housing Act is for. And so we thought, especially when it looked like compliance with the order was just nowhere in sight, we thought, well, if they have to pay us each 5,000 rand a month, at least we'd be able to house ourselves. That's the conceptual link, and it would completely resolve the case, because for so long as they go on disobeying the court order, we'll be able to house ourselves. And they will obviously want to bring the damages to an end as soon as possible, because they don't want to have to pay them for longer than is absolutely necessary, so they will comply with the court order. It will do two things that no other form of relief can do. It will make sure that we're fine from a much earlier date, make sure that we're housed from a much earlier date than we have been or will ever be housed. And it will it will keep the municipality and the respondents on their toes. That's what we say. And that's the appropriate link we tried to draw between the breach of rights and the quantum. It's not simply an amount to house ourselves, as the respondents try to suggest in their heads of argument. It is an appropriate and morally justifiable measure of the intangible and inquantifiable loss that we have suffered. That's what it is. But it has to be calculated in some way, and we found estate agents' advertisements about what it would cost to rent housing in Tembisa. We put them up, and we said it was 5,000 rand a month. That amount has never been disputed. The respondents try to suggest that it's a matter of expert evidence. That's palpably wrong in our view. Ordinary people enter into market transactions all the time. They're perfectly capable of telling you how much things cost them. Now, that's how we quantified the damages, and we think that the damages we've quantified are clear and ascertainable and undisputed. The next question, Justice Mhlantla, that you asked is, are they appropriate? And we submit that in the absence, as Justice Nugent said, in the absence of any other measure, any other proposal about what is appropriate, yes, they are. This court, in the exercise of its discretion, might reduce the damages to 3,000 rand a month. They might increase it to 7,000 rand a month. They might award this court might award a globular sum instead of an ongoing amount. All we say is that either accept the measure that we ask for, or follow the process set out in this court's decisions on constitutional damages and in the decision in Carte in determining an appropriate amount. Our primary submission, of course, is that damages must be awarded for all of the reasons we've given. Quantum we accept is more difficult. There's almost no cases on it. And the facts of the matter have changed substantially since we drafted the notice of motion. And as Justice Madgett has hypothesized, damages may be reduced or limited in terms of a bigger supervisory order where this court assumes jurisdiction to vary the amounts of damages payable. The one thing that is indisputable is that damages must be paid, because otherwise Thupetji's order meant nothing on the day that it came into effect, has meant nothing since then, and will mean nothing until the applicants get their houses in Esalen Park. That's what we say, Justice Mhlantla. It was so long ago since you asked your question, I'm tempted to say, does that answer your question, Justice Mhlantla?
Thank you, Mr. Wilson.
Thank you, Justice Mhlantla. Can I just make one more submission, Justice Turon, before presumably you ask the question that you want to ask? I want to head this off now because it's suggested in the respondents' heads that actually the damages, if they're awarded, should be reduced, having regard to all the difficulties that have been experienced by the municipality since the 1st of July 2019. They say there was a COVID lockdown, which obviously there was. There were protests, there were budgetary and financial problems, there were building delays. And what you should do is look at every month since the 1st of July 2019 and discount the months in which you think the municipality did its job properly. That is precisely the wrong way of looking at things. It's precisely the reverse of what you should do. What you should do is take the ordinary approach to court orders. And that is, if you don't meet a deadline in a court order, then you bear the risk of everything that happens after the court order comes into effect. My learned friends accuse us in their heads of argument somewhat shrilly of suggesting that we're wanting to enforce strict liability of a court, to implement a court order. Well, perhaps they could tell us what other standard is appropriate other than strict liability. That's what a court order is. It says, do this unless it is naturally impossible. There's no case of natural impossibility made out on the papers. And to suggest that somehow there are times that the municipality has been indisputably unwillful and unmala fide between the 1st of January 2019 and now, and so shouldn't have to pay constitutional damages for 4 months, is frankly conceptually muddled. The proper position is this. The rights vested on the 1st of July, they vested because a court said that they should vest. The municipality had years before the 1st of July to get it right. It didn't get it right. Doesn't explain to you any acceptable excuse why it didn't get it right. In fact, we know why it didn't get it right. It decided to provide flats at Tembisa Extension 25 instead of houses, despite the fact that the municipality and the respondents ought reasonably to have known that flats don't comply with the court order. That's not a gullible excuse. It wouldn't, but at least it is located before the date of compliance fell. Now what the respondents ask you to do is to look for excuses for them after the date of compliance fell. If you do that, then no court order sounding in money, sounding in or a judgment ad factum prestandum will ever be worth the papers it's written on, because the other side, the person on which the court order is binding will be able to say, well, I was going to pay you, but I lost my wallet on the way to the bank, and really it wasn't my fault because there was a hole in the pavement and I tripped up and the wallet fell out of my pocket. I would implore the court not to get in to debates of that nature. The line is clear. The municipality and the other respondents had every opportunity to comply with the court order before the 1st of July 2019 through choices they made. They didn't. And then they brought a variation application that stopped us from being able to enforce the supervisory portions of Thupetji's order. And now they try to say, well, ignore everything we did before, but there are some things we did after that we don't think are our fault. And if you're going to award constitutional damages, just subtract the days on which we weren't feeling well. With respect, no. The rule of law in this country, especially in respect of a court order, that it gives effect to constitutional rights, demands much, much more than that. The least it demands is a form of strict liability. Thank you, Justice Toronto. I think you had a question.
Thank you, Mr. Wilson. I have two aspects I'd like to explore with you. The one is relating to the compensation and further discuss the issue raised by my brother, Justice Jafta, and followed up by Justice Madlanga as well, and then jurisdiction. Let's start with compensation. If we look at Section 38, the enforcement of rights and constitutional damages, the damages are awarded in respect of a constitutional right that has been infringed. The constitutional right that has been infringed here by the applicants is located in Section 26(1), which is the right to access housing. Now, if this court is inclined to award the applicants constitutional damages, the amount of the damages should be determined with regard to Section 26(1). and not with having regard to the order that Thupetji gave. Because that is the right that has been implicated in this matter. If the applicants want relief in terms of the order, then shouldn't they then be looking at enforcement of that order and perhaps contempt of court proceedings for the failure to enforce the order, something which was also explored with you by my sister, Justice Chika?
Certainly the entitlement to damages does not arise in terms of the court order, it arises in terms of the Constitution. The Constitution gave form and effect, the court order gave form and effect to the constitutional right. So did
I'm sorry to interrupt you, but that was
yes.
as the court order was as a result of an agreement between the parties. So what is reflected in the court order may be at a higher level or standard than what is reflected in the Constitution. Now, to determine the measure...
Justice Turon, the court order of Thupetji.
Yes, wasn't it by agreement between...
It wasn't by agreement. It was vigorously opposed. There was lengthy argument about every part of it.
The aspect relating to the freestanding houses, was that not by agreement between the parties?
No.
No, then I'm sorry, that was my mistake. But in any event, shouldn't the measure of damages be determined with reference to the constitutional right and what is guaranteed by the Constitution? If one has regard to Section 38, Section 38 says you have to look at the right that has been infringed. And the right that has been infringed is Section 26(1), which is the right of access to housing.
Yes. So there are two responses. The first is that Justice Thupetji decided, I believe, that Section 26(2) had been breached. And that is the failure to take reasonable steps in terms of the laws and policies adopted to give effect to the right. So I don't know where that leads, quite frankly, but that was the finding made by Thupetji. The second point is this: there is, of course, the Constitution is what determines both the entitlement to damages, the appropriateness of damages, and the appropriate quantum. But the Constitution applies in multifarious ways. I think, as Justice Jafta pointed out to me, Section 26(1) means, or Section 26 of the Constitution generally, means different things in different circumstances. In our circumstances, it meant something very specific. It meant a subsidized house in terms of the RDP program that applied at the time the subsidy was approved over 15 years ago. The RDP program, the National Housing Code, and the National Housing Act. The Constitution applied through all of those instruments. So one can't separate the entitlements given to the applicants in terms of the housing subsidy scheme from the Constitution itself. This court, on many occasions, has set out the scope and meaning of an indirect application of rights through statutes. And that's what we say happened here. The right of access to adequate housing was given effect to through a statutory regime in terms of which all of the applicants qualified, and in terms of which all of the applicants were given houses. The failure to give those houses was a per se violation of the right to have housing in Section 26. The quantum and appropriateness of damages obviously has to be determined in terms of Section 26. But it has to be determined in the context of the way that Section 26 applied in this case. So at one point, Justice Turon suggested that, that the court order may set a higher standard than Section 26 does. And my respectful answer to that would be no, it doesn't, not in this case. The court order gives effect, plus some supervisory orders, to exactly what Section 26 entitled the applicants to in this case, because it gave, albeit belated effect, to the statutory and policy scheme that was adopted to give effect to the Constitution over 15 years ago.
Now, once again, if we're with you that constitutional damages must be awarded,
yes,
and if we were to find that the right that was violated here was the right of access to housing,
yes,
would the fact that alternative housing was offered to the applicants play a role in the determination of the amount? Because it's the right to access to housing that we would
which alternative housing, I mean, we don't concede that alternative housing that would comply with the court order has been offered.
No, not alternative housing complying with the court order. Alternative housing was offered.
So are you referring, Justice Turon, if I can ask, to the Palm Ridge houses?
Yes.
So there are 2 points there. It's not entirely clear on the papers that that offer was ever one that was extant. The date on which occupation would have been available to our clients moved with every piece of correspondence we received. The latest piece of correspondence now says it'll be available by the end of March. One of the problems with this case is that every time we receive a letter and an undertaking saying houses are coming, the date on which they're supposed to come passes and no houses there are. So that's one thing you would have. If you were minded to take into account the Palm Ridge offer, that's an aspect of the offer you would have to take into. The second point is this. We would say no, you shouldn't take into account the Palm Ridge house, because what we were entitled to in terms of the Housing Act, the National Housing Code, and therefore in terms of Section 26 of the Constitution, was a house that was constructed in Tembisa and that we were never given occupation of. When the court order was granted, it was granted to give effect to that entitlement. And or another agreed location part of the court order, which the Palm Ridge houses violate, was meant to ensure that what the applicants got was sufficiently similar to what they would have got had the breach not taken place. So if the misallocation that happened originally hadn't happened at all, we'd be sitting in Tembisa. It did happen, and that was a violation of our constitutional rights. In order to cure the violation of the constitutional rights, it is not, we submit, in any way appropriate to expect us to move 70 kilometers away, because it doesn't match sufficiently closely. We're not talking about perfection here, but sufficiently closely that of which we were deprived. And the court order is meant to give effect to that aspect of the obligation. It's not separable in our respectful submission from the nature of the obligation under Section 26. It's simply what Section 26 means in this case.
Mr. Wilson, in respect of the question of this court's jurisdiction, is it the applicant's submission that part of the reason why this court has jurisdiction is the conflicting decisions from the SCA in Kate and Komape?
That's part of our submission, yes.
Can you point me to the conflicts between these two cases, please? If there are any.
I shall have to get you, I shall have to get up the decisions in front of me. But before I do, the conflicts are simply this. In Komape, Justice Leach says that there is no reported decision in this country where a constitutional damages have been awarded for non-financial loss. The decision in Kati, as I've just set out, is plainly an award for damages for non-financial loss. Justice Nugent says absolutely clearly, this is not, the breach of constitutional rights is not financial in nature. Justice Leach says, well, I've never heard of a case in which constitutional damages have been given for non-financial loss. Justice Besson applied Komape's decision and had no regard at all to Kati's decision. And so the conflict, we call it a tension in our heads of argument. The tension between the two seems to be that Komape has led to a decision in the court below, in this case, that essentially says that the claim has to be for financial or patrimonial loss or for nothing. And Kati says exactly the opposite of that. Now, my learned friends say, well, you know, to the extent there's a conflict, Komape has overruled Kati. Well, we submit with respect not. We accept that the ordinary rule is that a later decision overrules an earlier one, generally speaking, but this isn't such a case. In Komape, there was no attempt to overrule CARTI. What Kamapi says is that CARTI decided that constitutional damages couldn't be claimed except for direct or indirect financial loss. And of course, that was an incorrect characterization in our submission of CARTI. And we submit that one court doesn't overrule another court's judgment if it simply misunderstands what it says. It simply clearly misunderstands what it says. One of the reasons why Kamapi came to the conclusion it did is because it thought it had support in CARTI, but it obviously didn't. And so we say that there are these tensions between Kamapi and CARTI, and that together with the urgency of the matter, the inherent urgency of the matter, means that this court ought to entertain the application on direct appeal.
As you know, Mr. Wilson, a mere misapplication of the law doesn't give this court jurisdiction. And hasn't, even though FOSI was decided before Kamapi or CARTI, didn't FOSI in this court settle the question?
Of whether constitutional damages can be awarded for non-financial loss?
Yes.
Well, I'm not sure it did, because the decision that everybody relies on, the decision of Ekurhuleni, is the minority decision. About how you approach questions of constitutional damages. I'm speaking without the case in front of me, but I don't think that anybody joined in Ekurhuleni's judgment. I think it was a lone dissent. If somebody did, it was maybe one or two people. FOSI was about whether punitive constitutional damages were appropriate in the circumstances. That was the question that seized the majority, and that's the question the majority decided. So in circumstances where there's a lone dissent by one judge, or maybe one judge with another judge concurring, I would struggle to see how this court has settled the question in those circumstances. Ekurhuleni's decision may well be persuasive authority, but the binding precedent in FOSI is the decision of the majority.
In respect, so there's two grounds that the applicants rely on for this court's jurisdiction: the tension between the two judgments and the question of urgency.
Yes.
Every court has a mechanism to deal with urgent matters, or to deal with matters on an urgent basis. The full bench, the SCA themselves, this matter could have been heard on an urgent basis in one of those courts.
Yes, but the point is simply this: that the urgency taken together with what we say is the conflict between Kamapi and CARTI is what grounds jurisdiction. Urgency on its own wouldn't have worked. The conflict between Kamapi and CARTI might on its own have engaged the jurisdiction of the court. But ultimately, I mean, justice, but you have to read both together. So what we say is that, going to the Supreme Court of Appeal, when the Supreme Court of Appeal has already given two judgments that bear on the question in a way that seems to us to be irreconcilable with each other, is not necessary if this court can resolve what we say is a tension on direct appeal. The jurisdiction, I mean, if you pitch the question at the level of jurisdiction, Justice Turon, the jurisdiction is whether this court thinks it's in the interest of justice to hear is on direct appeal. That's the jurisdictional test. And this court has in the past said that there are two things, there are lots more than two things, but there are two things that might persuade the court to hear a matter on direct appeal. The first is if there's something urgent about the case. And the second is if it's not, if the case is inherently constitutional in nature, and the views of the Supreme Court of Appeal, while desirable, are not essential. And it is on that basis that we assert that this court should decide that it's in the interest of we don't think that this court has jurisdiction or doesn't have jurisdiction simply because the matter is or isn't urgent, or there is or isn't a conflict between Kati and Kamapi. What we say is that the considerations that bear on the interests of justice that this court has enunciated before are illustrated in this case, precisely because you don't have to worry too much about deciding a novel constitutional question without the views of the SCA, because there are at least two decisions of the SCA that can be relied upon and drawn from. And secondly, there is a degree of urgency in this case. And so it is in the interests of justice that you grant leave to appeal directly. Of course, because of the inherent constitutional nature of the case and because of the paucity of the principles available to calculate constitutional damages and the long-running litigation between the parties, the matter would have ended up in the Constitutional Court anyway. There would have been a more, well, certainly somebody would have applied for leave to appeal. Whether you would have granted it or not is another question. And the delay in the interim would have been 3, 4, 5 more months, even if we were to employ urgent procedures, that our clients would have to stay in shacks. And we just say that it's in the interest of justice on all the circumstances of this case that delay be dispensed with.
Thank you, Mr. Wilson.
Thank you, Justice Terrell.
Mr. Wilson, there's something that bothers me. It's a different point altogether. Both my colleagues, Justice Jafta and Majid, have already expressed to you the sentiment that this court has towards wishing that there could be some form of resolution of the matter one way or the other. What bothers me is that at some stage, it seemed to me when I was reading the papers is that the parties were close to each other. They were close to resolving the matter until the municipality insisted that if your clients accept the alternative accommodation, albeit on a temporary nature, their shacks would have to be demolished. And my sense that I got, I could be wrong, is that once the municipality adopted that stance, it seems to me that the parties then drifted apart again. What I wish to hear from you is whether there's any principled basis why the applicants feel that even if they are offered alternative accommodation, their informal residences should not be demolished. And I think it's very important because it then will inform this court why your clients feel that way. And in the event this court would then decide to assume a supervisory role, then I think that would also be relevant.
Well, there are two answers to the question. The first is the reason why our clients instructed us that they didn't want to agree to have their shacks demolished on moving into the temporary accommodation was that the temporary accommodation would not accommodate each and every one of the applicants' households. So the proposal was never, we want to demolish your shacks if you can all fit into the flats. The proposal was accommodation in the flats is conditional upon an agreement that your shacks be demolished. And that is an agreement that we were instructed our clients could not make because there were people whose families, households would not fit into the flats offered as temporary accommodation. Justice Madlanger put the question to me and said, well, shouldn't this be determined on an individualized basis? Effectively, it's not exactly what Justice Madlanger said, but it would have been the result of what he put to me, that this would be determined on an individualized basis. And of course it should. But that is not the level at which the proposal was made or the condition was set. They didn't say, if those of the applicants whose individual families are able to be entirely accommodated in flats must agree to have their shacks demolished. And those of the applicants' families whose individual families cannot all be accommodated in the flats can remain in the flats. That was not the proposal. The proposal was the shacks must be demolished, come what may. And that's what we pushed back against. Then the municipality just abandoned it, abandoned the condition. And actually, that's not what pushed the parties apart at all, with respect, Justice Cheeky. It was the abandonment of that condition, actually, that, that made settlement, at least to future obligations, possible. Because then we were in a position where there was no unreasonable condition on the provision of temporary accommodation in flats. The only other thing that was required was a definite timetable that we had confidence that the municipality would adhere to for the implementation of the primary obligation in Tier 4J's order. What happened then was that there was an undertaking, or a best estimate. It's in the first affidavit in the application to introduce new evidence. It's right at the very end. The best estimate, the municipality said, is that your houses in Esalen Park will be ready by the 31st of the 30th of June 2022. And so the contours of the resolution that emerged was flats in Tembisa Extension 25 from the middle of this year, followed by houses in Esalen Park from the middle of next year. That was something that we were very keen on. The problem was that the municipality was never willing to nail its colours to that mast. It kept saying things like, but if we don't get the budget, we won't meet the deadline. But if there are unforeseen circumstances, we won't meet the deadline. And with respect, with the history of this case, that simply isn't good enough. But that's not all. In the latest set of correspondence that's been placed before the court in the application to introduce new evidence, the municipality says, hang on, we made a mistake. You're not going to get houses by the middle of 2022. You're going to get, well, there will be some land by the middle of 2024. And that land won't have houses on it. And we're not telling you when there'll be houses because there's no budget. In those circumstances, there can be no resolution because there's no undertaking to provide the houses. And there's a real fear amongst the applicants that their stay in flats is going to be on the never, never. They'll be permanently in flats. The court order will never be fulfilled. If the municipality can't even commit itself to a date, but even that is not good enough. It has to be a date that matters. There has to be some cost to the municipality of breaking another deadline. We've sought to create that cost through constitutional damages. It may well be that this court's supervisory jurisdiction is appropriate. Although, to be fair, the Ekurhuleni municipality in Pekel, the supervisory jurisdiction in that case lasted, I think it may well have been the High Court's supervisory jurisdiction ultimately, lasted a very long time. And it would be unfortunate if the length and if the time that had to be, the time and checks that had to be endured by the applicants extended further and further and further. Be that as it may.
I'm sorry to interrupt you. I'm now just thinking practically then, you know, and I know that I'm being too optimistic. If there was ever a middle ground, it would mean that the informal settlements or the informal residents would then remain in order to accommodate those family members who are not able to move to the flats.
Yes.
And then the municipality would then have to provide the alternative accommodation in the form of flats.
Yes.
And perhaps my concern is misplaced to say that I thought that when the municipality placed the condition that the informal residences must be demolished, it was also looking at solving another problem.
Yes.
The problem of having informal settlements in these areas in the first place.
Yes, I'm sure it was looking at solving that problem. I'm sure it wanted to say shack demolished, person in flat, tally up their numbers on the number of people they've put in formal accommodation. You may also have detected a degree of exasperation from the applicants when the proposal was made. It has to be seen in the context of years and years and years of broken promises and constant changes in plans and the moving back of deadlines. But if I can speak practically, the resolution of this case, practically speaking, actually giving the applicants houses, at one point seemed to be in the offing with an agreement that flats at Tembisa Extension 25 would be provided by the middle of this year, and houses at Esalen Park would be provided by the middle of next year. That was something we were very happy about, but that's not something that's any longer on the table. If for any reason, and I know my learned friend is listening to this debate, if for any reason that can be put back on the table, then the hypothetical that Justice Majid puts me begins to have some flesh on its bones. Now, we submit that damages should then be payable up to the middle of this year in some form on some quantum, and that a reduced amount of damages ought to be payable between the middle of this year and the middle of next year. But it really is up to the municipality to come to the party, because at the moment what we have is a series of accusations about how unreasonable we've been in the face of every change, every moved back deadline, every change between flats and houses, and how unreasonable we've been in saying we don't want to move to Palm Ridge. And really what's been happening all along is we've been saying, no, we'll accept that this is what we want. We want houses in Esalen Park and flats in Tembisa Extension 25. There's been an attempt to sort of completely ignore that position and paint us as unreasonable for not accepting other options, which when we're sort of presented in a maelstrom of letters that were not really relevant to the resolution that we'd already indicated we were very happy with. Of course, now we know why that was done, because Esalen Park was never really available by the middle of next year. It was always going to happen in 2024 and in some non-distinct date beyond. And on top of that, of course, we were not happy with the way that the municipality was saying, well, we'll keep our promises if it suits us to do so, if there's budget, if it's convenient, if you know, the builder comes to work that day. This is a court order and a constitutional obligation. We're way past excuses like that. Justices, we've covered a great deal of ground. It may well be that we've covered almost all of the ground that I wanted to take you through in my notes. If I could just have a moment to make sure that we've covered everything that I wanted
sorry,
to
Mr. Wilson, I'm concerned about the application to lead further evidence. I take it you're opposed to it, and if so, why? That's the only thing that I'd like to raise. Thank you.
We are opposed to the application to introduce new evidence. The two principal forms of opposition. Well, there are three forms of opposition, and we'll press two. The opposition set out in the papers is that the new evidence would only be relevant to the claim to constitutional damages if it could be said that there is a flat or houses available to that would comply with the court order that we can move into now. And that's never been said, and it can't be said. That's the position we take in our opposing papers. Now, that position might not suit, might not be appropriate to answer the hypotheticals that have been put to me by members of the court saying, well, what if we assumed supervisory jurisdiction, or we gave the High Court some form of supervisory jurisdiction? I'm simply saying, well, the new evidence isn't relevant in that event, would obviously be wrong. The new evidence would be relevant if this court were considering a wider set of issues than constitutional damages. But then there are two further reasons why the application should be dismissed. The evidence isn't new. Ultimately, the evidence as it has evolved isn't new. What you have at the end of this maelstrom of correspondence that has been directed to us and just attached to affidavits and an email to the court, what you have at the end of it is an undertaking. I wonder if you can even call it that, but an indication that land on which houses can be built will be ready in Esalen Park on the 30th of June 2024. That is really no different to the position that factually no different to the position that the respondents took in the variation application in the High Court. In their replying affidavit, in the variation application and the counter application in the High Court, the respondents said, well, houses at Esalen Park will be ready in about 5 years' time. The reference is at page 791 of the record, paragraph 27. So I'm going to check with Mr. Foss that that's correct. That is correct. So at page 791, paragraph 27, the respondents basically say two things. They say you can have houses in Esalen Park in 5 years. That's obviously too long a period. What you have in the application to introduce new evidence now, at the end of it, I mean, there are all sorts of swings and roundabouts in the correspondence, but the substance of the thing at the end is that they will provide houses at Esalen Park. They won't provide houses at Esalen Park. They'll provide land that is ready for houses at Esalen Park by 2024. That's not new evidence because it's something they've already said. And that's the only thing that's relevant to compliance with the court order when the court order is going to be obeyed. Also, the evidence isn't incontrovertible because the municipality has controverted it. The first set of papers in the application to introduce new evidence was meant to say, well, an in-principle agreement has been reached between the parties. There's going to be temporary accommodation in Tembisa Extension 25 by the middle of 2021. And then our best estimate is that houses at Esalen Park will be provided in the middle of 2022. We then wrote back and we said, well, now hang on, that's not an agreement in principle or otherwise. What we said to you as part of settlement negotiations is that sort of arrangement would suit us. But we're not agreeing to anything until we have the specifications for everything. And we have some assurance that these dates aren't just going to go by with another devil-may-care attitude from the clients. There's then some Sturm and Drang about that in the correspondence. We're again accused of being unreasonable in the most extreme terms and being in bad faith and resiling from an agreement that we say was never reached. Be that as it may, when the correspondence reaches its zenith in the documents that were sent to you 2 days ago, we saw that the agreement, if it was ever made, can no longer be effective because the municipality now says that we're not going to get houses in Esalen Park in the middle of 2022. So even if there was an agreement in principle, there isn't one now. Now, if the basis of, as I understand it, the basis of the application to introduce new evidence is, the new evidence is of this agreement. Now, if on everybody's version that is no longer the agreement, it's hard to see what happens to how the application to new evidence, to introduce new evidence can succeed, because the agreement has to be incontrovertible. But it's not incontrovertible. The applicants controvert it, they say we never reached it, and the respondents, at the very least, resile from it, and they controvert evidence of the agreement in that way. So it's incontrovertible, it's not new. The substance of the undertakings change at almost every stage of the correspondence. And so there's very little to be understood about what this is evidence of. For all of those reasons, we submit the application to introduce new evidence should be dismissed. We would like, with the court's indulgence, to refer you to Mwilasi, the Mwilasi case, paragraphs 43 to 45. It was a special master case, the case in which this court appointed a special master to supervise the land restitution process for labor tenants. And here, Justice Cameron deals with a very similar application to introduce new evidence, albeit in a different factual context. In this court, barely 3 weeks before the hearing, the latest new evidence is barely 3 days before this hearing, and nearly 8 months after the applicants lodged their application, the department belatedly applied to introduce further evidence. The applicants justly, this is paragraph 44, the applicants justly objected to this evidence. They pointed out that the department's affidavit was unsettlingly similar to an affidavit it tendered just over a year before in the Supreme Court of Appeal, including the heralding of the appointment to which it referred and repeated much of its content. In any event, the additional evidence simply did not meet what the rule requires. The new evidence must be common cause, incontrovertible, or of an official statistical or scientific nature. Besides, the applicants said, the evidence in reiterating previous unfulfilled assurances and promises tended, if anything, to support the land claims court order. All of these objections, this is now paragraph 45, all of these objections proved to be dismally warranted. On the back foot, the department conceded at the hearing that its supposedly new evidence did not match up to the rule's requirements. Instead, it now sought the admission only of evidence that the applicants accepted was common cause. That evidence, so far as it goes, far from showing that the department has turned the corner and is doing what it should be doing, tends to show the opposite. It evokes the image of a department as engaged in a hopeless Sisyphean struggle, condemned eternally to roll a gigantic boulder arduously up a hill, only as the top nears for it to roll down to the bottom, time and again, the labor doomed to be repeated forever. Now, the similarities, although the facts are very different, the principled similarities to this case, insofar as the application to introduce new evidence goes, are most striking. As I've already submitted to you, the evidence is not new. It's merely a repetition of previous unfulfilled assurances and promises. We were first promised houses would be built at Tembisa Extension 25 by July 2017. You'll find that on volume 4 of the record, page 354, paragraph 2. The first reference we can find to the Esalen Park promise to build houses is the reference I've already given you, page 791. And there, the respondents say that the houses will be ready by 2024. Now, of course, they just say the land will, the houses won't. So that's the repetition point. Just like in Mwilasi, this evidence doesn't meet the test for the introduction of new evidence. It's controversial, it's controvertible, because the respondents themselves have controverted it. They said there was an agreement that we would be housed by the middle of 2022. And then they sent a letter showing that that really wasn't going to happen. So how could there have been an agreement? And finally, the evidence tends, if anything, to reinforce the applicant's case that nothing is currently being provided that will comply with the court order, and nothing will be provided in the near future that will comply with the court order. There is, as Bassanjay herself said, no end in sight. So for all of those reasons, Justice Majid, the application for leave to appeal should simply be, the application for leave to introduce new evidence, I should correct myself quite sternly, the application to introduce new evidence should be dismissed with costs, because there's just no point in having any regard to it. If I can just take a moment to see if there's anything else that we haven't covered. If I can take an instruction from our learned friend, Mr. Foss. Oh,
Yes.
Justice, another question.
Yes, sorry, if I may. Please, can you remind me, what was the individual subsidy amount that was approved in respect of each of the applicants?
In 1998 prices, it would have been in the region of, I want to tell you 45,000 Rand, but I'm not sure that's correct. My learned friend, Mr. Foss, is looking at the record now.
Yeah.
I imagine, yes.
If we work on an average of about 40,000 Rand amongst 133 applicants, it would be an amount of just over 5 million that would have been allocated.
Yes.
If we were inclined to grant constitutional damages, should we have regard to that? And we don't want to have the situation that we have had in the news about the cost of cleaning schools, costing the government more than to build the actual school. And,
yes.
And if we're looking at damages here in the region of 15 million, and it costs 5 million to build the houses, what would your submission be on that?
Well, look, the first submission I'm going to make is probably not an important one, but I'm going to make it anyway because it's factually relevant. Of course, 40,000 Rand in the late 1990s is not 40,000 Rand now. 40,000 Rand in the late 1990s is significantly more now. But this isn't the kind of exercise we're engaged in. I've submitted to you that this isn't an actuarial exercise. So I can't very well rely on strict inflation or rises in the cost of living in response to you, Justice Tyrrell. All I can submit to you is that it is absolutely appropriate for you to have regard to that, Justice Tyrrell. It is absolutely appropriate for you to keep the damages within acceptable limits. And we wouldn't suggest otherwise. The basis on which we calculated the damages was we had nothing and we had no future hope of anything. Now, on the hypothetical that Justice Madgett is putting to me, an appropriate order may well be to cater for the future problems by reference to an appropriately robust an appropriately robust order supervised by this court, and to deal with the past wrongs by an award of damages that may appropriately be, ignoring inflation, in the sum of 45,000 Rand per person. I can't honestly submit to you that that wouldn't be one appropriate balance to be struck, given all the considerations that you said are relevant, Justice Tyrrell, and which we agree are relevant. Can I just take an instruction from Mr. Foss on the value of the subsidy? I just want to take you to the record, volume 2. And this is exactly why I needed to take an instruction, because my estimate was completely wrong. If I can take you to volume 2, page 151 of the papers. The subsidy amounts awarded are recorded there. I don't know if the court is there.
Yes.
15,000 Rand.
It's 50, it's not 45. Perhaps I'd calculated I'd factored the inflation in my head without telling you. But the subsidy amount at that time was 15,000. And so the submission, I don't think, changes, Justice Tyrrell. Obviously, it's something you ought to have regard to. You ought probably also to have regard to the fact that 15,000 Rand then is not 15,000 Rand now. certainly not 15,000 Rand on the 1st of July, 2019. But the, as I've already submitted, this isn't an actuarial game. And so all of these figures and facts have to be balanced. All we say is that we've put an amount forward, we've made the calculation of it clear, we've made the purpose of it clear, we've made the way that it's linked to the right that's been breached clear. Nobody has ever suggested that any other amount is appropriate. That is as far as we can go. What we do say with vigor and without qualification is that damages should be awarded. And what we have proposed is one of the things the court will take into account when it does the exercise of quantification.
Thank you, Mr. Wilson.
Mr. Wilson, Mr. Wilson, tell me if we can take judicial notice of the following.
Yes.
One, that the Minister of Finance has at least twice said that we borrow at least 1 billion rands per day. Two, that the municipality that draws from the same kit as everybody else has, like all of us, suffered budget cuts. Now, the first question is whether we can take judicial notice of that. And also whether we can take judicial notice of the fact that many people, even in state-owned enterprises, have been and are being retrenched, reducing the contribution to the tax to revenue, and increasing the inability to pay for raised taxes and services. The first question is therefore whether we can take judicial notice of that, and if we can, whether that is a relevant factor in dealing with whether or not in this stage of our economy, constitutional damages would be appropriate, or whether it's an irrelevant consideration. And maybe before you answer, they have taken off my picture. I think they've picked up something. I didn't do it myself. Yes, Mr. Wilson.
Thank you, Chief Justice. You certainly shouldn't take judicial notice of any of those things, because those facts stand in isolation, and they stand without any direct relevance to this case. If you're going to take into account all of those things, then there are 10 other things that we would like you to take into account of that we haven't been able to put on the record because nobody has suggested that we need to answer any of those cases, any of those individual facts. For example, Mr. Foss just flashed before my eyes a figure that suggests that there is a capital budget surplus in the municipality of something like 4 billion Rand expected in 2023. Now, capital budgets is where we'd expect construction to come from. I'm not advancing that as a fact, and I don't want my learned friend to worry that it's part of my case. It is not part of my case. But the problem with judicial notice of complex social and economic facts is that they always exist in a particular context. The context has to be isolated and distilled in a particular case. And the facts that one takes judicial notice of relating to the economic recession that we're currently experiencing and the various financial difficulties that you alluded to, Chief Justice, those exist in a specific context, that is required to be evaluated. And if they were pleaded, we could respond to them. They're not pleaded, so we can't respond to them, and we can't really make any meaningful submissions about how they would apply in this particular case. For example, all governments borrow. The collapse of American civilization has been announced for at least 30 years, given the scale at which its national debt is escalating. What are we to make of that? All governments are in debt. How much debt? How does it impact their socioeconomic obligations? To what extent does the reason why governments go into debt matter? Is this particular government in debt? These are all questions that would have to be taken account of in addition to the particular fact of which you wish to take judicial notice. So while I haven't considered the narrow evidentiary question of whether those various media reports can be judicially noted, I would imagine they were some form of hearsay, so I'd say not.
I beg your pardon, the minister, the budget speech of the minister falls into the category of various media reports and budgetary cuts as well.
Well, let me make a distinction between the budget speech and the media reports. The budget speech is presumably a proceeding in Parliament, and of course would in principle be admissible evidence. I would object strongly to it being admitted against us at this stage in these circumstances. The media reports would I think be hearsay and not capable of judicial notice. I haven't considered or researched the question. So on the narrow admissibility question, I'd say probably not, except perhaps the budget speech. On the general, should you take judicial notice question, I would say no, because you're taking judicial notice in a vacuum. The other, I don't know if Chief Justice, you're trying to ask a question.
No, I think once you say it's irrelevant and you've made those preliminary submissions, I'm happy to leave it there rather than prolong it longer than we have.
Thank you, Chief Justice.
All right. You still have submissions, Mr. Wilson. I don't think I may be wrong with ever kept counsel as long as we have kept. It's almost 3 hours on your feet.
Well, I'm very glad not to actually be on my feet, Chief Justice, but I do have 3 more points to make. I'm actually going to make it 3.5, and I'd like to make them very, very quickly, if I may.
Talk time now. Yeah, no. Yeah, let's talk time. How long? You're almost
without,
there.
Without interruption, no longer.
Making submissions for 3 hours. Let's try and manage it now. How
Thank
long?
you, Chief. Without interruption, 10 minutes. Maximum.
Yo, that's quite some time. But go on.
Can I say 5?
Yeah, better.
Okay.
Yeah, that's much
5 minutes.
better.
The first point was the second part of my answer to your question, Chief Justice. And of course, if one is going to take judicial notice of things like that, one ought to also take at least judicial notice and probably pay some sort of principled obeisance to the fact that what we're talking about here on one level is the rule of law, the rule of constitutional law and the obedience of court orders. That is something on which our entire economy is based. If you start sending the message that court orders don't matter, don't have to be complied with, don't have to be given effect to, because of some of the excuses that have been advanced in this case, the very fabric of the system starts to unravel. And that too.
No, I'm sorry, Mr. Wilson. I'm sorry. That's not what I had in mind. I'm basically saying, in view of the fact that it's well known that we are our economy is in a junk status, how much, if any, should we give weight to that reality? That's all. I wasn't saying that the plight of those people should be trivialized or court orders should be, the disregard for court orders to be disregarded. I'm just
I'm
saying,
sorry.
The courts have been criticized for not keeping abreast with the realities, and I think unfairly so. It's a reality that we are in junk status, we borrow as heavily as we do, and should we look for an alternative other than constitutional damages? That's all I was seeking to have you make submissions on.
And the very short answer is that we don't know how those big social facts apply in this case because they haven't been pleaded. They probably have very little relevance. And secondly, if you do take account of those big social facts, you also have to take account of another big social fact. And that is that the basis of our economy is the rule of law. And this case is all about the rule of law. My own view is that judges ought, and I say this very respectfully, to pay attention to the law primarily and very little else. And insofar as economics are relevant to the law, then you can take account of economics. But I don't think it's a criticism of the judge that he doesn't read the newspapers and know what the NASDAQ is doing today, or what the rate of inflation was yesterday, or what the state of the national debt is. If it's relevant to a case, you ought to know. But if it isn't, it doesn't matter that you don't. There are 3 further submissions, and I'm going to make them very quick. The primary alternative remedy that the respondent suggests we have is a cause of action in delict. Given the questions that I've had from the court, this doesn't seem to me to be an argument that is particularly, this court has moved the court very much. Our submission on that is simply this: there is no action in delict because the National Housing Act says there's no action, or doesn't say that there's an action in delict. And that's something that the respondents have just never dealt with. In FOSI, and it's a passage we rely on in our heads of argument that I won't take you to, Justice Ackerman sets out a series of cases that say that the breach of a statutory right and the breach of and therefore the breach of a constitutional right is only gives rise to an action of damages in delict if properly constructed, the statute intends to grant that action. Now, we've made the point in our heads of argument that the Housing Act and the National Housing Code don't grant such an action in delict. And of course, the Constitution doesn't grant such an action in delict. It grants an action in constitutional damages. There's just no answer from the respondents on that point. Delict is a non-starter. There's some allusions to fault being established on the facts, et cetera, and perhaps a trial being more appropriate. The facts in this case are completely undisputed, and so is the municipality's fault. So what a trial in delict in this case would do, what good it would do to the judicial exercise and the fact-finding exercise is respectfully entirely beyond us. The applicants, the respondents also say that we should have asked for a special master to be appointed. This is overlaid by the incorrect submission that we never asked for supervisory jurisdiction. Of course we asked for supervisory jurisdiction. That's what Thupetji granted. There seems to be a sort of dim recognition of that in the heads of argument for the respondents. And they say, but what you should have done is asked for a supervisory order with a special master. Problem is the respondents don't say what a special master could achieve that has eluded 2 judges of the High Court and 5 judges of the Supreme Court of Appeal. Special masters are meant as referees to courts when complex policy questions are to be confronted. They're not meant to determine how a court order is to be implemented. They're not meant to enforce obligations that are clear and on their face, that are clear on their face. This court expressed itself on the circumstances under which a black master, a special master is appropriate. In black sash, which is what I was struggling to say. I just want to refer you to paragraph 39 of Ekurhuleni, where the conditions under which a special master, the appointment of a special master is appropriate, are set out. And essentially, the court says, well, in black sash, the complex failure to implement the social security system across the whole country, that didn't warrant a special master. Of course, in Ekurhuleni, the facts did. If that's the line, somewhere between black sash and Ekurhuleni, it just seems to me to be extremely odd to be suggesting that a special master is appropriate in this case, which is about building houses for 139 people. Sorry, 133 people. The municipality does that all the time. Why does it need a special master to tell it what to do? So, I mean, the idea that we haven't asked for supervisory jurisdiction is nonsense. The idea that a special master would help is equally nonsense. Our final submission relates to the respondents' complaints about the open-ended nature of the damages we seek. I've already substantially covered that, but I'll make the point again. The open-ended nature of the damages we seek, that they must carry on paying damages until they comply, is made in the context of an assumption that there is no further supervisory jurisdiction that this court will exercise on the hypothetical that has been put to me. There is, as Justice Besson has set out, no end in sight. It actually takes seriously the municipality's assertion, which probably shouldn't be taken seriously, that the earliest it can comply with the court order is 2024, well, sometime after 2024 when the houses are built. If there is going to be no end in sight, then of course the damages must be open-ended. What else would they be? How else would the right be vindicated? But I think we've traveled quite a road this morning. Justice McQueen has pointed out how long I've been heard for. And so if the resolution of the court were to be constitutional damages for the period between the 1st of July 2019 to the day on which the court order is complied with, varied once we move into the temporary accommodation, then and is willing to control the quantum and the award of damages by assuming supervisory jurisdiction, then the open-endedness objection that my learned friends make really falls away. It won't be open-ended, it'll be subject to a supervisory order. I can just take one instruction. Thank you, Chief Justice. Those are our submissions for now.
Thank you, Mr. Wilson. Colleagues, I think we need a break. We didn't anticipate that this long when we decided not to have a break. But if you tell me otherwise, I'm happy to call upon Mr. George. Should we take a break? 10 minutes break, or should we proceed?
Justice, I hardly heard anything you said, but I think towards the end I heard, should we take a 10 minutes break? And if I heard you
well, then we'll for 10 minutes.
Personally, I would be happy with 10 minutes, Chief Justice.
Yes, thank you, Chief Justice.
Well, I see that it's almost 1 o'clock. Why can't we take a break for 30 minutes? Including lunch. I see that my colleagues confirmed, but the CJ doesn't see them, I suppose.
Justice Jafta, the Chief Justice has lost connection. Justice Kampepe.
Muted, Justice Kampepe.
Oh, colleagues, can you hear me now? Can
Yes,
we adjourn for 10 minutes?
Our brother Justice Jafta came in, CJ, was yeah, you had lost connection, and he suggests, what about the lunch break for 30 minutes?
That's fine. Let's take a 30 minutes lunch break. We'll come back at
Yeah, see
If I can be of assistance, I heard the Chief Justice say that we would take a 30-minute break and be back at 1:30.
Oh, okay. Thank you, Mr. Wilson.
Thank you very much.
I'm always very happy to be able to help in these circumstances.
Ohini.
Okay. My sister, are we adjourning for 30 minutes?
Court will adjourn for 30 minutes until 1:30. Please note that during the adjournment, you are welcome to...
Thank you, Mr. Wilson. You had me well.
I'm afraid I didn't hear that at all. I just heard my name.
I think the Chief Justice was saying you heard him well, Mr. Wilson.
Oh,
Okay.
thank you, Chief Justice.
May I continue, Justice Taran?
Yes, you may, please, Ohini.
Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 1:30. Should you exit, you may use the same link to rejoin the hearing.
Thank you.
Colleagues, are we all back in?
I'm here, Chief Justice. Not sure if everybody's back.
LT, are we all in?
I'm checking, Chief Justice.
All right.
Justice Chitli, are you with us?
Cheers.
Okay. Justice Matlanga is here, yes. Justice Kampepe, are you with us, Justice Kampepe?
Yes, I'm here. Can you see me?
Yes, thank you. We're all online, Chief Justice.
No, thank you so much, colleagues. I kept on connecting, disconnecting, and they have advised that I use my phone. My face won't show. Please pardon me, but at least I'll stay connected. Are we ready to start?
Yes, we are, Chief Justice.
Thank you so much, Justice Tyrone. Mr. Georgiades.
Trying to get my camera on, Chief Justice.
Thank you.
Chief Justice, the reaction I'm getting is I can start my video. The host wouldn't allow me. All right, I'm here. I'm ready, Chief Justice.
Yes, you have 10 minutes without interruption. And as for the rest, we'll see how it goes. I thought we would be much shorter with Mr. Wilson, but circumstances did not allow. So 10 minutes, and then we'll see how it develops thereafter.
Thank you, Chief Justice. Chief Justice and members of the court, I want to start off by making the case as to why supplementary affidavits should be allowed. And the submission is that they're incontrovertible, they're common cause, and they're in fact very relevant. They're relevant because it shows the efforts that have been made by the municipality to house their applicants. One of the elements, one of the things that it does is it points directly to what we submit is the unreasonableness on the part of the applicants in not accepting the accommodation that's on offer. We say that in relation to the Palm Ridge accommodation that's been made available. We also say it in connection with the flats. And I would have thought that once the court had put to my learned friend that the question of a structural interdict or supervisory order was one that the court would look at, he would have abandoned the case for constitutional damages, but I'll get to that submission in a moment. In the correspondence, the correspondence is relevant because it shows exactly how we've been engaging as a municipality with the applicants in order to comply with the order. What it does show is that the goalposts have been continuously shifted by the applicants. Once they were, the starting point is their 1st of December letter that with a 1st of December 2020, that's to be found at volume 1 of the supplementary affidavit. At page at page 34, where they accept the issue of flats pending the construction of their houses at Essendon Park. That's a letter from their attorneys on dated the 1st of September 2020. This is in reaction to our letter of the 5th of October. If you go back to page 20, you'll find the offer of interim accommodation in RDP apartments at Clayville Extension 60 and Tembisa Extension 27. So it says after Palm Ridge in the paragraph 3.1, I'm referring to the next soonest available accommodation is the Clayville apartments, which are expected to be ready for occupation by November to December 2020. And the top structures at Clayville are closer to completion than the Tembisa 27 apartments, which should be ready soon thereafter. What then happened was, after accepting on the 1st of December, the walk-ups or the flats pending the houses in Essendon Park, is that the applicants do a complete turnaround And what the correspondence indicates, without taking without taking the court to every single correspondence, is that suddenly the issue of specifications became a requirement, and we had not given the specifications of the flats at Clayville or the flats at Tembisa Extension 27. We submit we'd already done that, but for purposes of trying to settle the matter, and when I say settle the matter, I mean in compliance with the court order made by Thupetji, we then gave those specifications again. But just before that, the issue that was picked up by one of the justices earlier, I cannot recall which justice, I think it was Justice Taron, was that it was Justice Cheeky rather, it was the issue of the informal houses, the ones that they're living in at the moment. On the 2nd of December, there was a meeting held, and one of the questions that arose was what would happen to their existing shacks for the extended families. And that became a sticking point to settlement. So that's why I say the goalposts kept shifting. We acquiesced to that. The municipality acquiesced and actually offered those, offered that the shacks remain until such time as the houses in Esalen Park are constructed. So whilst they lived in the flats, the informal structure would still be in existence. They then changed tact and said that we hadn't given them any of the specifications. Once we afforded them again the specifications, then they suddenly say, well, there's no houses on offer because you can't give us a specific date by which houses will be built on the property at Esalen Park. Initially we did, and we concede that we gave a date of 2022, but that had shifted to 2024 for the preparation of top structures at that time. And that is where the negotiations break down, and the correspondence yields the fact that they don't want to engage with us anymore. They see no purpose in meeting with us because there's nothing on offer. Whereas we've put all these offers to them as real and tangible offers, they say there's nothing on the table as yet. And they seem to be hell-bent on getting constitutional damages. Once, that brings me to the next submission. So on that basis that we say that the papers or the correspondence should be put before the court. It also yields that the Clayville is ready. And if you look at the supplementary bundle at page 148, the second volume, justices will see that Clayville is ready from March for occupation at mid-March 2021. That's at page 148 of volume 2. So it's on that basis that we say that these supplementary papers are relevant and that the court should have regard to them. If the court doesn't have regard to them, then we're looking at what happened yesterday and not what's happening today. And that won't serve justice in our humble submission. That then brings me to the point about the supervisory order. The supervisory order that my learned friend says he would agree to is something more than the supervisory order that was made by Justice Teffel. We seek that a referee or a master be appointed that can actually engage with the parties and bring the parties together. It's not for the court to bring us to the table. It's this third party that will summon us and have powers to bring us to the table. That would be a very useful exercise, and it would lead to the expedition of the issues and the housing of the applicant sooner rather than later. But once there's flats on offer from mid-March, and once there's a supervisory order in place, my learned friend says that we should still pay constitutional damages. We can only envisage that constitutional damages then only serve one purpose, and that is to punish the municipality. That is to punish the municipality for one thing and one thing only. And that's because my learned friend says court orders must matter and the rule of law must matter. We agree that we've breached the court order. We agree that we haven't fulfilled the court order. But we say that the applicants seek to escape having to prove any fault or wrongfulness on our part, any malafides, which would be a requirement in a case of contempt. Instead, they don't bring a contempt case. They rest assured that constitutional damage will serve to vindicate their rights or vindicate the rights in terms of the court order. we make 4 points in our heads, and that is that, sorry, before I leave that point, I just wanted to refer to the judgment at page 70, at Foss's judgment at paragraph 72. It's in the judgment that's quoted often in all the cases. It's quoted in Komape and in Kate's case. It's that of Justice Ackerman. And paragraph 72, he states the following: in a country where there's a great demand generally on scarce resources, where the government has various constitutionally prescribed commitments which have substantial economic implications, and where there are multifarious demands on the public purse and the machinery of government that flow from the urgent need for economic and social reform, it seems to me to be inappropriate to use these scarce resources to pay punitive constitutional damages to plaintiffs who are already fully compensated for the injuries done to them, with no real assurance that such payment will have a deterrent or preventative effect. It would seem that funds of this nature could be better employed in structural and systematic ways to eliminate or substantially reduce the cause of infringement. So there's no point that judicial notice either be taken into account or not of the current state of the economy. But further than that, we make reference to exactly that in our correspondence with the applicants. And that's the court will find at page 110. It's in volume 2 of our supplementary papers. And in particular, paragraph 30, if I'll be permitted to quote. In respect of finance, we say the following: importantly, the municipality's finances are constrained and not within its control. The municipality undertakes to do all in its power to apply for budget for SL. For example, the municipality applied for 100 million funding for its province, only approved about 33 million. Are not there merely for the taking upon request, as you suggested in your replying affidavit. It is well known that the government budgets throughout the country are generally limited and have been recently additionally limited because of COVID and the resultant economic hardships. The municipality undertakes to apply its best efforts and to do what it can within its powers to apply for and obtain the necessary reason why these papers ought to be before the court in our respectful submission. But we make 4 submissions in relation to our case. We submit that Justice Passon properly categorized this case, where at paragraph 83 of a judgment that justices will find at page 865, she said the following: likewise, there's no reported case to which the parties could refer me to where a court ordered constitutional damages in essentially a case of contempt of court. And this is what you're being asked to do. You're being asked to, because of the contempt, because of the breach of the order made by Justice Teffel, to award damages to the applicants. Our 4 submissions are the following. The first is that there are alternative remedies, and we're by no means saying that constitutional damages ought to be the last resort. We don't say that. We say that where there are alternative remedies, the alternative remedy of contempt of court or supervisory, a supervisory order or the delictual claim would have been a preferable or rather an alternative remedy that would have been available to the applicants had they utilized it. Instead, they seek to circumvent what the fault element in delict and contempt in order to come to justices, to the Constitutional Court and ask for constitutional damages. When they ask for constitutional damages, it's our submission that the element of fault doesn't feature at all, and neither does the element of wrongfulness. The court will see that from all the correspondence and the affidavits that have been exchanged, that the municipality has made some effort in order to comply with the court order. It's gone to the lengths of offering houses, albeit that the houses in Palm Ridge are some 60 kilometers away. They are houses that are available at this point, and that in our submission would serve to comply with the court order. My learned friend says that it was only in Tembisa, but it could have been any other agreed location. Unfortunately, they didn't agree to Palm Ridge at all. And that's not even dealt with by my learned friend until one of the justices raised it before. So the constitutional damages is they escape having to prove the element of fault on the part of the municipality. And the reason why they don't go by contempt on their own admission is that they won't come right and they won't be able to prove mala fides on the part of the municipality. We submit that if they can't prove mala fides, if they can't prove fault, if they can't prove wrongdoing, then why should they be awarded with constitutional damages? It then sets the bar for constitutional damages much lower than those for a delict, contempt, or a supervisory master, as we've suggested in our papers, in our written argument. The second point, and the point that Justice Basson also raised, is that of the punitive effect of an order. The amount of 15 million rand comes in relation to 23 months where since the 1st of July 2019, when the court order was meant to be fulfilled. This doesn't take into account the issue of lockdown at all, or the months that the municipality wasn't able to construct because of the lockdown. And that also goes to the issue of the amount sought, or the computation of the amount is not structurally sound. And I'll address the court on that point in a moment. But the third point is the far-reaching effects, and I've already dealt with it somewhat on state organs if they were to be liable for the late service delivery. Government departments would be unduly burdened with having to deliver services, essential services that they're entitled, the communities are entitled to in terms of the Constitution. But if they were late or the municipality transgressed, then constitutional damages would be warranted. That's the effect of what my learned friend's asking the court to.
And Mr. Georgiades, the 10 minutes has expired.
Then lastly, the last point was the point on the Kate judgment and the Komape case.
Sorry, Mr. Georgiades, before you get there, I'd like to raise 4 aspects with you, but not in the sequence that you've done it. I'd like to start from the bottom up. So the point that you've just raised about the far-reaching effect on the fiscus and on state organs of state, if we should allow constitutional damages here. In Kate, Nugent J.A. said that questions of constitutional damages must be decided on a case-by-case basis. Do you accept that?
Yes, that's also decided in FOSSI. I do accept that.
And therefore, it means that it wouldn't be just opening the floodgates or opening the doors to everybody. It'll have to be fact-specific depending on the circumstances of the case. Do you accept that?
I accept that, but with one qualification, Justice Majid, and that is that if we're to be settled with constitutional damages in this case, the message is clear, and the message is that if there's no delivery pursuant to a court order where rights are infringed, then constitutional damages would be apposite, or late service delivery in any context would be such facts and circumstances that would arise and that would allow constitutional damages.
Well, all I can say to you is that ignores the whole history of this case. And I'm not being, let me say this, the cases that I've seen that resemble this is probably PECO, which also comes from your client, by the way, yes. And perhaps Life is a Demeni, but I've yet to see a case where there's been such wanton disregard of court orders going to a court in the last minute, literally, to seek variation. Be that as it may, I want to turn to the second aspect because I know my colleagues will have questions for you, so I don't want to take up too much time. The second aspect, and I'm working my way back up in the sequence that you've done, is the punitive aspect. Punitive in what sense? They've not received any compensation. I always understood punitive damages to mean that you've been compensated for something like, for example, a delict, for a loss of support claim and so on. And now you seek further damages, constitutional damages beyond that. And that is typically what happened in Komape, isn't it? The claim yes. for additional damage for the right to a peaceful family life, that was declined because on that basis, it's also been yes. said in other cases that punitive damages means there's already been compensation paid. So in what sense is the punitive, is constitutional damages punitive here? Explain that,
Well,
please.
they'll be punitive because the right to housing has been vindicated and the issue has been resolved by the court order that was made before Justice Teffo, as amended by the Supreme Court of Appeal. Once that right is...
I'm sorry to interrupt you. A court order is meaningless if it's not implemented. I mean, that court order is not worth the paper it's written on if nothing is done to implement it, not so.
Yes, Justice Majid, but on the flip side of that, it doesn't mean that every time there's a delay in implementing a court order that constitutional damages are warranted.
That's not what I'm putting to you. I'm saying to you that what I'm raising with you is that on a case-by-case basis, based on the facts of this case, surely there's nothing punitive in constitutional damages should we be so inclined. It's another question whether it's coupled with an additional order such as a supervisory order, such as the one I postulated to Mr. Wilson earlier. But what's punitive about it? Explain that, please.
It's punitive because the applicants haven't suffered any patrimonial loss. They're not out of pocket with regard to any damages that they've suffered, pecuniary or otherwise. What they do is they seek they seek a bargain. They seek to get 5,000 Rand per month going forward, even in a situation where they'll have flats. So once they have flats and they accept flats from mid-March, they'll then entitled to a windfall of constitutional damages. On that basis, that's punitive.
But Mr. Judge, I'm sorry to be debating this with you, but you must stating the position. You must have heard Mr. Wilson earlier say, when I postulated that hypothesis, he said, if they will gladly accept the flats at Tembisa, and there must be consideration then of constitutional damages from 1 July 2019, when their rights vested, 1 day after the deadline imposed by the SCA, up until not the flats offered, but when they actually accommodated in the flats. Up until that point, there must be constitutional damages of 5,000 Rand per month per applicant, he says. Thereafter, there should be reduced constitutional damages until the houses in Esalen Park are already taken up. So that is the basis. So there's no question here of getting a windfall.
It is a question of getting a windfall because 5,000 Rand is not even properly computed with respect.
Have you contested that? You know, you say that this is a desktop valuation. You don't come back and say, well, this desktop valuation is wrong. Here's a different desktop valuation. I can do better than that. How does that kind of litigation work?
We don't want to controvert. We didn't want to controvert it because we don't want to get into an argument as to what constitutes a reasonable amount of rental in the Tembisa area. But it's for them to prove that the amount of 5,000 Rand is what's warranted in the area. In our submission, 5,000 Rand rental is what's warranted in renting a house in the open market, not renting the type of house that's on offer, which is with respect an RDP house.
Right. Let me deal then with the third aspect. I'm almost done. This is the penultimate one, I promise you. You said earlier that it's not your submission that a claimant or a plaintiff must first exhaust common law remedies before turning to constitutional law remedy. Then how does this, I'm reading from your heads now at page 5, the written submissions, page 5, paragraph 5.1. You say, and I quote, we submit that alternative remedies ought first to be explored by the applicants. What does that mean? It must first be explored by the applicants. And remember here you're dealing with constitutional damages. What does that mean?
We say that the point that we seek to make, Justice Majid, is that alternative remedies, if alternative remedies are followed, for example, contempt of court, let me just use that as an example. They would have to prove mala fides on our part. They bypass that element by coming to court for constitutional damages. So they're now relieved of proving any fault or wrongdoing on our part. And if one has regard to the way we've approached this case, we can make a case that we've acted without malice. And that's their fear in bringing a contempt application by their own admission. And my learned friend considered that in his argument.
Yeah. Again, you know, one doesn't want to approach this like ordinary litigation, but you're almost trying to say there is stop from proceeding in this fashion until they've done a contempt. They've said they've chosen not to do a contempt of court application, and this court must take it into consideration, not so.
Yeah, they have chosen that, but the reason why they've chosen that is to relieve themselves of having to prove the element of willfulness or mala fides with respect,
Yes.
Justice Smith.
Yes, we'll take that into consideration. My last aspect that I'd like to raise with you is this. You criticize the applicants at length for being unreasonable. You do so in the papers, you do so in your written submission, and you do so also in the letters. And I'd like you to take you to one letter in your supplementary bundle. That's bundle 2, volume 2 of your supplementary papers, page 164. That is a letter that was written to your attorneys by Ms. I think Ms. Is it Ms. Zondo? The attorney for Seri was acting for the applicants, and that was on the 16th of February, a day before yesterday. Ms. Zondo, that's correct. Now she says this, and please stop me if you disagree with anything that's said here. I know you haven't had a chance to respond to this, but she says your clients first assured our clients and the SCA that houses would be constructed at Tembisa Extension 25 by 30 June 2019. That did not happen. That's correct, isn't it?
Yes, that is correct.
Your clients then gave their best estimate that houses at Esland Park would be ready by mid-2022. That also turned to be wrong because now it's 30 June 2024. That's right, isn't it?
Yes, it is correct.
Then we go. I skip to paragraph 6 now. In your letter of 5 October 2020, with regard to the flats, it was stated that flats at Clay will be ready by November or December 2020. That date is now March 2021. That's still right, isn't it?
That's correct. Justice Majid,
sorry, let me just finish. In your letter of 2 December, I'll give you a chance now. In your letter of 2 December 2020, it was stated that flats at Tembisa would be available in May 2021. That date now appears to have been moved back to 30 June 2021. The point is this, Mr. Georgia Hadjis, the point that she's making here on behalf of the applicants is that the goalposts keep on moving, it keep on being shifted. So can you blame them for being skeptical and to a point almost cynical about any promise or undertaking that's made by this municipality to them as poor, indigent, suffering people? Can you blame them?
I don't take issue that they're poor, suffering people, Justice Majid. In response, building houses is not an exact science. You can't say that a house will be built by a specific date and that a house be built by a specific date. The question of budgetary constraints always enters into the picture. The question of lockdown entered the picture in this case. But we say that notwithstanding all of that, if they are not to trust us, even with a supervisory order, then there's no point in making a supervisory order, because every time we say that the houses will be ready by X date, they'll second guess us and they'll say, well, there's no offer and we don't want to engage with you. We don't want to sit at a table and negotiate with you.
The Judge, I know you said this is the last question, but I'd like to conclude again with a hypothesis that I postulated to Mr. Wilson. Are those flats in Tembisa Extension 27 available for occupation within the next month or two? Firstly, and secondly, would they be able to be accommodated at those flats pending the construction at Esland Park?
The flats in Clayville will be ready, as I understand, in mid-March, as I've already submitted. The flats at Tembisa Extension 27 will be ready by the 30th of June, and they are allowed there. That offer is made clear in our supplementary papers. In fact, we were the ones who proposed that in our letter of the 6th of October. It wasn't the applicants that proposed that. We proposed that they be housed in flats.
That's not so important. That's fine. The point is, and then on that basis, their structures at the moment, so not temporary structures, very much permanent for them. The informal structures at the moment can remain.
We've said that. We made that undertaking in the correspondence, and that's why we wanted to put the correspondence before the court. But just going back on that, the first time that they've actually accepted flats was that letter of the 1st of December 2020. The second time is here in court.
Yes, thank you.
They've never accepted flats. Up till now, they've never accepted our offer for flats pending the construction of houses in Esland Park. And the reason they do that is because they want to keep their constitutional damages claim alive.
Thank you.
They want to punish the municipality. The deterrent effect it can only be punishing if the municipality is to pay constitutional damages to the amount of 15 million rand for 23 months. It'll be a period of 23 months from the 30th of June 2019, when the judgment of Justice Tefo takes effect, the 1st of July 2019 until now. That doesn't even take into account the two issues, the issues of the original owners of the house. The house is in the name of some of these applicants. We're told that there's only 2 such applicants. When Justice Jafta puts to them that why didn't they pursue a claim in regard to that to get the house back, they could have mitigated their damages, but they come to court asking for damages in the maximum amount of 5,000 rand per month, wanting the municipality to pay 15 million rand for a period of 23 months. The other intervening act is the issue of the lockdown. Why should the municipality have to pay damages during the period of the lockdown when it couldn't construct houses, especially during the hard lockdown? But let me carry on with my submissions.
Sorry.
Okay.
Mr. Georgiadis, I'm curious to know, why has the municipality not complied with Thupetji's order?
The reason, Justice Jafta, is that originally you'll see from the court order that it was envisaged that Tembisa Extension 25 be the land where the houses were to be built. During the time between the order that was made by Justice Tefo and the appeal to the Supreme Court of Appeal, this changed from freestanding houses into what we call walk-ups or flats. And that then became unacceptable to the applicants. The issue of flats didn't arise before Justice Tefo at all, because they weren't envisaged for the property that was envisaged at the time. It was only once we offered them the flats that they rejected the flats.
Did that issue of flats arise before the SCA? Because my understanding is that the SCA adjusted the dates on which compliance was required of that order.
The SCA did adjust the date. They added another 6 months or, to the order so that it would be 30 June 2019. That's right. But the issue of flats didn't come before the SCA either. I stand corrected, but it didn't come before the SCA. Is that right?
Why not? Was your client not aware by then that it won't be possible to comply with the order in respect of the freestanding houses?
I stand corrected. My juniors seem to be saying that it appeared in the reports that flats would be built. There was going to be a densification of the area, quite right. So that was, but it wasn't anything that was mooted before the courts. The assumption on our part was that they would accept the flats, or they would accept a house of 40 square meters.
Well, you see, I find it difficult, Mr. Georgiadis, that if your client was wishing to comply with the court order and circumstances had changed to the extent that it would not have been possible for your client to comply with the court order at the time the matter was before the SCA, why would the change of circumstances not brought to the SCA and a variation of the order sought? Because the impression created now is that apart from the adjustment of dates, we went to comply with this order, when that was not the issue. The real issue was your client could not deliver freestanding houses, as at the time the parties were before the SCA. So the adjustment of dates could not achieve the obeyance of the court order. Why was that
not in terms of freestanding houses, Justice Shafter, that's correct. We couldn't comply in terms of freestanding houses, and that's why we brought an application to seek clarity on that aspect before Bason, although we must be criticized for bringing that application late.
Okay, thank you. Thank you, Justice Madlanga.
Justice Matlanga, you muted.
Mine was to have been more a comment. I don't know if I shouldn't just let it pass.
Okay.
You, in response to Justice Majid, you itemized a lot of things, even including saying that the applicants should have mitigated their damages by seeking an eviction. I just felt that it's rather rich for the municipality to be saying all of those things. It is, and I think Mr. Wilson was quite correct in saying that it's wrong for us. Yes, insofar as they're claiming the damages, they're saying they peg them on the order by T4J. But I think Mr. Wilson was quite correct in saying that we cannot forget the history. This stems from the 1990s. And I will just call it what I think it is. And in fact, it may well be a euphemism, but I will say due to municipal bungling. And who knows, maybe worse, the applicants didn't get houses that they should have gotten a long time ago. So I do not think it is correct for you to itemize all of the things that you were itemizing in response to Justice Majid.
Justice Matlanga, I take the criticism, as my client should take the criticism for not being, providing houses to the applicants when they were supposed to be. Whatever bungling was done has happened, and it's there, and we can't wish it away, unfortunately. What we are in court for is a issue of constitutional damages, and that arises from the period of which we were meant to comply with the order to date, and who knows, to date into the future. It's not going to serve any purpose to grant constitutional damages other than to punish the municipality for past transgressions and not complying with the court order. It can only be for not complying with the court order. It can't be for its conduct prior to the order. Otherwise, they would have claimed damages from those dates. They would have claimed damages for a much longer period than they have claimed. But
Mr. Georges, I'm not sure whether I follow you when you are responding to the question by my brother Thupetji. At the SCA, paragraph 4 of the judgment, it states that the municipality states in its updated progress report dated 8 May 2018 that the project manager estimates that the houses in phase 1 will be completed and ready for the 134 respondents to occupy by 30 June 2019. That was an undertaking that was made by the municipality.
yes,
And it refers to the houses.
yes, it
And
does.
the question was, I didn't follow your response to the question that was put to you. If you look at what was said to the SCA.
What is also contained, it's also contained in our report at page 461 of the papers, where we say that we will commence construction of the houses in phase 1, and that construction was meant to commence in November 2018. But we did say in that report is dated 8th of May 2018, that based on the diagram, phase 1 houses consist of black and red units. The black color units are blocks comprising of 56 units. There are 3 blocks in phase 1. There will be 4 floors in height, and the red blocks comprise of 24 units. There are 46 red blocks depicted in phase 1. And then we say the time period for the completion of these is to be on the 30th of June 2019. This was the report that served before the Supreme Court of Appeal. So
and in that report, you were talking about the houses. So the issue of the houses, you were clear that that will be done by end of June 2019.
No,
so the question was, why didn't you comply?
Justice Mklanta, what we do say in this report is that page 461 of the record, this was the SCA ordered us to provide it with a report before it rendered its judgment. And in the report, we clearly state that they're going to be flats, and they're going to be 4 blocks. These will be 4 floors in height, and that there would be different blocks, but that there would be flats provided and not houses. Sorry,
paragraph 4 of the judgment, refers to houses, which would be completed by 30 June 2019. And that was a basis on which the order of Thupetji was extended until 30 June 2019 to allow the municipality to complete the construction of those houses.
Well, it seems that the SCA didn't take cognizance of the fact that what we placed in our report was that flats would be built. And we regarded it as one and the same. When we said houses, that's why we sought clarity, because when we were before Justice Teffo, the issue of flats didn't arise. This is what's changed during the time that we were litigating this issue, and on appeal, it turned from houses into flats.
Mr. Judge, if I can perhaps assist, paragraph 4 of the SCA judgment refers to a report dated 8 May 2018.
Yes.
Is that the report that you are also referring to?
Yes, it's the relevant part is at page 461 of the papers. That is the report. Thank you.
Are you saying the SCA got it wrong in referring to houses?
Let
me just finish, please, Mr. Chichana. When in fact, in your report, you refer to flats. Is that the submission that you're making in response to the question from my sister, Justice Mhlantla?
I don't think, when we litigated the matter before Teffo, I can definitely say that the issue of flats didn't arise. When we litigated the issue before the SCA, the issue of flats didn't arise. It was only once the SCA ordered us to compile this report that the issue of flats had arisen, and we put that in the report. I can only say that the SCA didn't distinguish the one from the other by saying that the flats weren't houses, and that's the basis upon which we litigated the matter before Basonjay. Obviously, I'm not making that submission now. I'm not making the submission that Teffo meant flats or houses, but it's something that happened. There was an intervening act.
Mr. Georgiadis, you repeatedly referred to Thupetji as Teffo. It's Thupetji, please.
Sorry, Justice Madlanga. I meant the Teffo order. We've always referred to it as the Teffo order. I apologize.
No. On these last two occasions, you just
sorry.
Teffo did this. Teffo did this.
I apologize.
Thank you.
Mr. Georges, though, the judgment of Basonjay clarified that issue.
Yes.
At para 49 of the judgment, Basonjay did say that what was the Thupetji judgment actually meant a plot of land with a house, not flats. That was clarified in that judgment.
It was, but then the question arose from Justice Majid, or was it Justice Jafta rather, that the issue of why the houses weren't built, it was because once the flats manifested, or once the flats surfaced, the applicants rejected that as a notion, and then we were back without any houses for the applicants, looking for alternatives. And one of the alternatives that we eventually found was the lands in the Esselen Park development, and also that in Palm Ridge, which they never accepted. But they now accept, or they seem to have accepted on the 1st of December last year, that they'll accept flats as temporary accommodation pending the construction of houses. I think that was also accepted today in court, but in between, there's a lot of correspondence that was exchanged between the parties where there was no such agreement.
Mr. Georgiadis, may I on that point just follow up what my sister Mhlantla Jay has been asking you, and perhaps take you to the judgment of Thupetji at volume 4, page 371 onwards. The learned judge gives a useful exposition of the act after discussing Grootboom. She gives a useful exposition of the legislation and also then the housing code.
Yes, Justice.
Are you there?
Page 371.
371 at volume 4. This is on the question of houses and flats, and I know this is the Thupetji judgment where flats did not feature at all. I'm very cognizant of that. So bearing that in mind, the learned judge discusses Section 3 of the Housing Act, and we know that the Housing Act is one of the legislative measures that government has taken in terms of Section 26(2) to give effect to the right in Section 26(1) of the Constitution. We accept that?
Yes.
So it speaks in Section 3, sub 4G of government, the minister, as the Minister for Housing or Human Settlements, as she's now called, the minister may institute and finance national housing programs. Then we turn to Section 4, which deals with the housing code. And this is the important part that I'd like to emphasize, is paragraph 43 of that judgment, which deals with part 3 of the National Housing Code. It then says, upon approval by the MEC of the application, that's an application for the subsidy, and the developer of the housing having been advised accordingly, the developer must proceed to A, transfer the property, that is the land without a top structure, to the beneficiary, and B, complete the housing product, that's the top structure, that's the house, in accordance with the subsidy agreement on the relevant property. The point I want to make is this: do you accept that in enforcing their right, a right which vested for the latest on 1 July 2019, the day after the SCA imposed deadline, that vested right entailed the following: applicant, let's say Mr. Thubakgale, the first applicant, applied for a housing subsidy in accordance with the Housing Act and the Housing Code promulgated under that Act, for a subsidy which was approved for a house, not for a flat, and that house was supposed to be built in terms of Part 3B of the code for Mr. Thubakgale on that land allocated to him, and thereafter had to be transferred to him. Do you accept that? That was the right that vested in him. Do you accept that?
That's correct, Justice Majid.
Now, if Mr. Thubakgale then comes to court, he says, look, I was awarded a subsidy, let's say late 1990, in the late 90s. We don't know exactly the time. I suspect it's around 98 or 99. He may have been one of the first. Be that as it may, in late 1990s, I was granted a subsidy. And then I was shown a plot of land that was allocated to me by the municipality. On that, in terms of the Act and the Housing Code, which flows from the Constitution, I was expecting to be given a house for my 15,000 rand subsidy. That never materialized. After many, many engagements up until the highest office in the land with the presidency, I then turned to court. That court said, yes, you are right. That house should have been built and it must be built by such and such a date. That was appealed. The date was adjusted. Never happened. You went to court to vary the date and to change it to flats. Never happened. Wasn't changed. And now they're before us appealing the refusal to award constitutional damages. Do you accept that Mr. Thubakgale, on these set of facts, is entitled to a house in Tembisa as allocated as I've sketched?
Well, he's entitled to a house in Tembisa or any other agreed location, and the one agreed location now seems to be Esalen Park. So I do agree with it.
Yeah, it seems that in principle he's accepted that, but he cannot be compelled to accept a flat as permanent accommodation. You accept that?
I accept that.
Yeah. All right, thanks.
I accept that. We don't make a case. The issue of flats arose after the order of Justice Teffel, and that was served before the SCA, and the issue of flats didn't enter the minds of the parties until the development at Tembisa Extension 25 evolved into one that was going to be for flats.
Well, it just seems to me to be an unhappy turn of events that when you were asked to do a report, you did a report saying phase 1 will be ready by X date. And phase 1 was actually not, as your report correctly indicates, it shows multi-level buildings, that's apartments or flats, as we know, walk-ups, and not houses. And unfortunately, it seems that the SCA did not pay attention to that particular aspect and proceeded as if these were still houses. That's an unhappy turn of events. But I just wanted to clarify that.
Yeah, yes, it is a turn unhappy. It is unhappy, and it's quite right that we went before Justice Basson to seek clarity on the aspect, because we try to bring the case that they should accept the houses, or they should accept flats rather. Unfortunately, Justice Basson disagreed with us, but she did agree with us on the issue of constitutional damages. If I can just have a moment to, before I continue with my submissions. What is this point? The issue of not wanting flats only arose in May. Initially, there was discussion at some of the meetings, and that's in our replying affidavit at page 791. The replying affidavit that's dated or signed 4 September 2019 that served before Basonjay. The residents' representatives were also made aware of a housing project in Esalen Park. However, this housing project is some 5 years away. I think my learned friend read from this page, from completion. Obviously, this was too long a period for the residents in this case. The residents were offered plots with houses in Palm Ridge and in Tsakani. These are in the process of being constructed and comprise of plots of land with houses. The residents refused these as they were some 40 kilometers from Winnie-Mandela, where they currently reside. The residents were also told that it's not possible to construct houses where they currently reside due to the dolomitic nature of the land. It seems that they refused to accept this explanation, even though it was raised as far back as the proceedings before the December 2017 court order. So there was a communication relating to the issue of flats with the residents, but it seems that they then didn't accept the flats, and that's why we litigated before Justice Basson to clarify that issue. Unfortunately, we were told that there would be freestanding houses and that we must accept. But all the housing developments in Ekurhuleni at the moment, because of the dolomitic problem, seem to be flats. And that's why we've struggled to, even Esalen Park, but we've made an exception in the case of the applicants to build freestanding houses as they're entitled to. And we concede that.
Mr. Judge, may I just check with you, as your client, has the municipality ever budgeted for the houses for these applicants? Ever, I mean, as from, ever.
What the municipality did is say that they will include the residents in one of their housing projects. So the budget
when did they say that?
That's what we've been exploring since the beginning, since the order that was made, or since the clarification of the order, flats versus houses by Sonjay.
So that means that before that attempted variation of the order failed, you've not budgeted it. Is that what you're saying?
No, we didn't budget specifically for the applicants, no. What we did is we include them in the housing projects, and we try to find an appropriate housing project in which to house them. Unfortunately, most of them are walk-ups and flats, which they've rejected, and the court via Basonjay held were not acceptable. I don't know if that answers.
Judges, I'm sorry, I'm troubled by that. I'm troubled by the answer that you have given. As I understand, the municipality knew that it had liability and responsibility to comply with the order of Thupetji. Why would the municipality not budget for meeting that responsibility? Why would the applicants would be included in some other housing projects? I don't understand that. Unless from the word go, the municipality never intended to comply with that order.
No, Justice Shafter, that's not correct. The municipality envisaged that the houses, when they were still houses, before they became flats, would be allocated to the residents, to the applicants. And that was solidified by Thupetji in her judgment.
But how would the municipality comply with that order without budgeting for it?
Well, they must have budgeted for it because they budgeted for the project. So the project was Tembisa Extension 2025. That's the order that's referred to in the order of Thupetji or any other agreed location. So once the houses are budgeted, then you're effectively budgeting for the applicants. Because you're saying you're going to build so many houses and you're going to allocate those houses. The first houses would be allocated to the 133. That was the municipality's intention before it changed to flats.
No, but then if there was a budget,
yes,
to meet this order, why was it not met?
Because it changed. The development changed. Well, it changed from houses to flats.
No, you have an order that says deliver houses. You think on your own, I'm going to include compliance with this order in some project. And that project, the goals change into flats, and therefore I'm not going to comply with the order. Is that what the municipality is saying?
No, because at that stage, the municipality didn't regard flats as not being houses. That's why we sought clarity before Basonjay.
So Georgiadis, I'm still confused, but let me not keep you long. I thought, as at the time, the parties were before the SCA, which was before the matter was taken before Basonjay.
Yes.
Your client was aware that it could not deliver freestanding houses.
My client assumed, Ekurhuleni assumed that the flats would suffice. That the flats would suffice to accommodate the applicants. And perhaps that was presumptuous, because then it had to go to court. Once the flats were rejected by the applicants, it had to go to court before Basonjay and get the correct clarity. But to answer the question, once the court order was made, we understood, and we had earmarked extension 25 in Tembisa for the applicants. So they were budgeted for, and the idea was to include them in the freestanding houses that were to be built there. There were some 1,500 freestanding houses that unfortunately evolved into flats. And we assumed that they would take up the flats. Perhaps we were too presumptuous.
Were there flats ready for occupation on the date extended by the SCA?
No, they weren't. Because extension 25 becomes extension 27, and they're not ready. They're only ready at the end of June.
How did your client expect to comply with the order?
Well, there were delays, of course, in constructing even the flats. And that's brought us to where we are today. There's budgetary constraints. There's the issue of the lockdown that delayed them. We explained that in our papers. No,
but the issue of the lockdown, does it cover the SCA's deadline?
No, it doesn't. It doesn't. The SCA's deadline was before the issue of COVID.
Yes. Then your client was aware, and mind you, it's government, which must lead by example. It was aware that it could not comply with the order as adjusted by the SCA. Did your client go back to court and say, I'm asking for more time? These are the difficulties that I've met with, and I won't be able to comply with this order?
We only went to court on the eve of the expiration of that date, of the SCA's date.
Okay. Thank you.
And that was one of the grounds upon which we were criticized by Basonjay. But with respect,
Mr. George, just as a follow-up on this last question, the project in Tembisa and the flats, were they not for identified beneficiaries from the inception of the project itself?
No, when we were going to build 3 houses, we had already earmarked the 133 as beneficiaries.
Were they already part of that project, or was it meant for other people who were going to be bumped out to accommodate the applicants?
Justice Tlelati, I can't answer that question. I don't know specifically if they were earmarked for specific people and whether those people were bumped out in order to comply with a court order. All I know is that once the court order was made, that there would be the 133, the applicants before you today, would be included in the housing project.
But what is before us, you already know that for the applicants to have had these rights, they were already identified from the inception of the project itself. I thought that's how the municipalities operate. So that would mean that they would have been intended for specific beneficiaries and would be still sitting with the same problem that they were going to bump out other people.
It could be the case, Justice Thupetji. I don't have any knowledge as to who was earmarked for those houses. And obviously, when it changed to flats, there would be more people that would be identified and more beneficiaries. And that's one of the reasons why it evolved into flats. There would be more beneficiaries, and it also took care of the dolomitic problem that we referred to, that I referred to.
Does that mean that the applicants were not treated as a special case to be included in the municipality's integrated development planning and spatial development, so that the court order could be complied with?
Once the court order was made, they were so treated. They were to be treated as a special case, and that they would be included in the Extension 25, which has now become Extension 27 plans. Yes, that's correct.
I see. Thank you.
Mr. Georgiadis,
yes.
The Thupetji's order in 1.3 envisages that the parties should, throughout the process, be in consultation with each other, in the sense that it specifically says that there should be certain reports to the residents through their attorneys and all of that. My question really is going to the issue of the change of plan by the municipality, not to construct houses, but flats. And that assumption that the municipality made was it conveyed to the residents, that is now the applicants, that in fact we are no longer going to be building houses, but flats. And so even before you conveyed it to the SCA through your order, were the applicants aware, in fact, of the developments in compliance with the Thupetji's order?
Yes, there were meetings held with the representatives, and that's the page 791 of the record that I referred to, where the residents' representatives were made aware that the housing project in Essendon Park was 5 years away, and that in the process there would be constructed there would be flats that would be constructed because of the dolomitic nature of the land. That was communicated to them in the meeting, and that's where they signified the flats were unsatisfactory.
So are you then submitting that when you went to the SCA and when you submitted that report to the SCA, the municipality was aware that the applicants were not happy with being allocated flats?
No, because the meeting took place after we went to the SCA and after we reported to the SCA.
Yes.
When we went to the SCA, we were asked to compile the report. We then compiled the report, which signified flats, and more or less at the same time, we had a meeting with in compliance with the order, and told the residents that flats would be constructed instead of houses. And that's where
my initial question pertained to the initial period, because at the Thupetji's order, it says that the municipality should deliver written reports to the residents. So my initial question was, when the municipality then had a change of plan, initially before you approached the SCA, when it had a change of plan and realized that in fact, what it considered to be suitable was the building of flats rather than self-standing houses. Was this communicated to the residents? That was my question. And in compliance with Thupetji's order.
It was in the context of the meetings that Thupetji ordered, that's right, where this was communicated to the residents. I don't know if that answers your question, Justice Chiki.
No, it doesn't. It doesn't, because what I wanted to satisfy myself was whether at the time you presented that report to the SCA, stating that in fact these were not self-standing houses but were flats, you had already informed the residents that in fact there was a change of plan.
No, the answer is no, we hadn't. We must be criticized for that. We hadn't done that.
Now, a follow-up question on the Palm Ridge issue. I can't put my finger on it now in terms of the time frame. Did the housing in Palm Ridge become available before the SCA? Before you went to the SCA or afterwards?
Well, only after we went to the SCA, Justice Chiki.
Thank you.
Those houses became available. In fact, the houses only became available in the last year in 2020.
Thank you.
So they wouldn't have been available at that time.
Thank you.
I just want to make the submission regarding the conduct on the part of the municipality. We don't come to court to say the municipality is blameless, and we obviously accept all the criticism that's been leveled by the questions posed by the court. But we must bear in mind what damages are being claimed. They're constitutional damages that are being claimed from the time of the court order till now, and they can only be damages because we haven't complied with the court order. And the message that will be sent out is, if you don't comply with court orders and there's a right that is infringed, you're going to be liable for constitutional damages. And that seems to be punitive. That seems to be in addition to any other relief that can be sought in terms of contempt. And constitutional damages seems to be, it seems to me that the bar would be lowered if this court were to award constitutional damages, because it would do so without demonstrating any mala fides on the part of the municipality. The applicants quite rightly don't attempt to show any mala fides from the time that the order was not complied with.
Just on another point, during my debate with counsel for the applicants, I posed the question concerning the impact of an award of constitutional damages on your budget and your financial constraints and your service delivery functions and so on. And the response that he gave me was that, in fact, you don't deal with this issue at all. And I had to agree with that, but subject to what you are going to submit, that in fact you've taken, or you've asked this court to allow you to file supplementary affidavits twice, yet you do not say how, or you do not tell this court how an award of constitutional damages would impact those issues.
We do say, we say rather vaguely, we don't say specifically what we've got in the kitty, and we haven't made provision for constitutional damages, that much is clear. But we've said that it will have far-reaching consequences on the municipality and its service delivery. That is one of the submissions that we make in our heads, is that if we were to be punished, and I can only say that it's punitive because of the submissions that I've made before, or the submission that I made before in the questions that Justice Majid posed, it can only be punishing because we don't make any provision for this kind of damages, and that we would obviously, it will obviously impact on our service delivery should we be ordered to pay 15 million rand plus whatever amount we'll be ordered to pay during the time that they occupy flats, where their rights are somewhat vindicated. Having accepted that, we shouldn't have to pay anything during that period. But be that as it may, our learned friend says that we should, because we're not fully in compliance with the court order. It just sends out the message that the message that where you don't deliver on services, you could be punished by having to pay money that's actually destined for service delivery. So to answer your question, Justice Chiki, we haven't budgeted for that amount. We'll obviously have to pay it, and it'll have a negative impact upon our service delivery ultimately. And that was recognized by the court by the court in Mboweni and the court in Fosi, making the, and I've made that point about scarce resources already in the past. What we also do at page 110, and I referred to it earlier in my arguments of the of the second bundle, which is volume 2, we say the municipality's finances are constrained and not within its control. We do get our budget or our finances from Treasury and from the province in particular regarding the service delivery of houses. We say the municipality undertakes to do all in its power to apply for budget for Esselen Park. For example, the municipality applied for 100 million funding for Esselen Park to province for the present financial year, but province only approved about 33 million rand. So we were only given a third of that which we asked for. I can only imagine that if we order to pay a substantial amount that is sought by the applicants in this case, it'll take further away from our funds that are available for services.
Mr. Georgiadis, is it open to the respondent to raise budgetary constraints when they were paid, they received a subsidy in respect of each of the 133 applicants?
The amount, unfortunately, because of what happened in that misallocation of the houses, the amount, as my learned friend informed the court, was 15,000 rand. It'll take a lot more than that to build a house today, but we accept that responsibility, that they deserving of the houses, that the court has ordered us to build them houses. But there should be, and regard should be had to the budgetary constraints of the municipality, definitely, in answer to your question, Justice Thuron.
And that problem was caused by, I don't know what's the appropriate word to use. So, yes. If the money that had been allocated for the applicants had been used for houses for the applicants, the respondents would not be finding itself in the situation it is now.
That's correct, Justice.
So what I'm saying is it open to the respondent now at this stage to rely on budgetary constraints when it has put itself in this position through its own administrative bungling?
Well, it's punished enough in the sense that it'll have to build houses on the modern day amounts and not the old amounts. Obviously, if it built the houses back when it was meant to, it would only have incurred an expense of 15,000 rand. Now it's incurring an expense of 10 times that if we wanted to take a rough estimate. But regarding the issue of constitutional damages, it's our submission that our budgetary constraints should be taken into account because of exactly what he said in Fossey and in the other cases where the state resources must be looked at. They're already stretched. And I'd agree with the Chief Justice Mogoeng. Although he didn't positively assert the point, he asked my learned friend, in fairness, whether the state of the economy should play any role. It always does when it comes to the question of resources. But I accept the criticism, Justice Thuron.
Georgiadis, I'd like to just return to questions that was asked to you, I think by my sister Tiki J. And that is, or it may even be by Jafta J earlier, and that is the question of when this densification decision was made. And I just want to track the sequence of events with you. After the SCA judgment, which altered the date, one of the things that happened in the correspondence and the engagement between you and SERI on behalf of the applicants was that SERI's attorneys complained about the fact, on behalf of the applicants, complained about the fact that you were not complying with the order, you as a municipality, and having failed to set up steering committees and providing reports. And a number of items of communication were exchanged. And one of the things they complain about, and I'm in at volume 7 at page 695 and 696, they complained about the fact that, and this is the point that was raised when I asked you about the budget and which Justice Jafta followed on with you, 697 actually. You said to them in a letter, it's cited at 57.1, paragraph 7 of the letter, of your letter, states that you, that is the applicants, must bear in mind that the Tembisa Extension 25 housing project will consist of 3,510 units. It's impossible for our client to continuously update you. And then you say at 57.2, paragraph 9 of the letter concedes that the residents' homes are not specifically referred to in the reports. Your clients are 134 in a development of 3,510 units. Now, they then make the point, rightly so, and I want to ask you about this. This is lumping them together with all the other beneficiaries And surely you should have given them precedence and priority because they have a court order that says that you must build houses for them.
Justice Majid, it's correct that we should give them precedence, but once the housing project turned into flats, because when you refer to 3,510 units, it's already become flats. We could have housed them in those flats specifically, but they refused the flat.
And this is the point that I'm getting to. Then they make the point that as these things progressed, well, it didn't progress actually. As things didn't progress, they then went to court for a contempt of court order, which is what we've been talking about all the time. And what happened then? You undertook then to report directly to them, not so?
Yes, we did.
And on that basis, they agreed to withhold that contempt application. In the course of in the course of that engagement, when they received direct reports through direct meetings with you, they then became aware. They said that the goalposts have now shifted in two ways. A, there was going to be densification of the area. Now we're talking about flats, no longer houses. And B, the date has been shifted way back. And they say that's the first time they become aware of it. Do you accept that?
Yes, I must accept that. That is what happened.
So here's the thing that I'm putting to you is, had it not been for your non-compliance with that court order of Thupetji in the sense of having a steering meeting set up where they are also represented, and for failing to give them regular reports as required by Thupetji's order, they would never have been in a situation where they had to go to court and then find out that there was densification. A decision taken, A, without their knowledge, B, without consulting them, and C, in complete defiance or at least oblivion to that Thupetji order, not so?
I wouldn't say, I would agree with everything except the oblivion of Thupetji's order. I think that they regarded the building of flats as compliance with the order.
I really find that hard to accept. I really find that hard to accept. But assuming for the moment, just for purposes of this discussion, that is correct. How then could they make that decision without either going back to the court or at least engaging these applicants?
Well, once we did engage them, they rejected the flats.
Exactly.
Yes.
They made it clear they won't accept flats. They opposed your application for a variation of the order before Basonjay, and then they sued for constitutional damages. It's not in vacuo. It happened. All these things happened, and then they said, well, they really said, we've now reached the end of our tether, and therefore we are going now for constitutional damages as a counter application. Not so.
Yes, but constitutional damages only arose. Once we brought the application before Basonjay, they brought a counter application for constitutional damages. And they only sought those damages from the time that we were meant to comply with the order of Thupetji as amended by the SCA. But our conduct doesn't, with respect, merit constitutional damages because we are not mala fide. We're not at.
That's not a requirement for constitutional damages, Mr. George. As I understand the law, all that we need to do is to consider that these applicants have decided they've chosen not to go the route of a contempt of court application. They say why, and we must assess if those reasons are justified, and then see whether in infringing their rights, you must be held liable to pay constitutional damages. Having said that, I want to put one last question to you. In Metropolitan, the SCA said with a similar type of argument that, well, contempt of court proceedings is a blunt instrument.
Yes.
A, and B, it doesn't prove to be an effective remedy or appropriate relief because it doesn't achieve its purpose. Yeah, it wouldn't put the applicants in the houses that they should have had long ago. Not so. Do you agree with that?
It wouldn't have, but I submit that they would have to prove malice if they brought contempt. It would be harder for them to.
Well, in that case, the SCA also said in the place of a blunt instrument like contempt of court, much better have a structural interdict, a supervisory order. And is that not the way to go here then if we discount a contempt of court application?
But with respect, Justice Majid, we're the ones that offered the structural supervisional role in our heads and in our papers. And the applicants never took it up until it was offered to them by the justices this morning.
Well, Mr. Georgiadis, let me make it very clear. I'm not saying a structural interdict as an alternative to constitutional damages, but rather complementary to constitutional damages.
No, I understand that. I understand that, but there's been a lot of engagement that is contained in the supplementary papers where the applicants have acted unreasonably too. Although the municipality is to be criticized for its conduct, the applicants also to be criticized because they could have accepted flats a lot earlier than this. They could have accepted flats way back when as an interim, way back when we offered them Esalen Park, which was something that was already on the cards shortly after the order by Thupetji was made.
Well, Mr. Georgiadis, I took you through all that correspondence. We've been there, we've done that. Yeah. There's skepticism, and in fact, their cynicism is justified, I think, on the facts, just based on that correspondence, based on those assertions in the affidavit.
Yes, but now you would have seen that they've broken off all engagement with us solely because we can't give them a specific date. So they say there are no houses, and then we can't engage with them. So the structural interdict would assist. But the granting of constitutional damages won't serve any purpose other than to punish the municipality and to attempt to deter it in the future, which is something that the Fossey judgment clearly doesn't agree with. If you read the paragraphs of Ackerman in paragraph 71 and 72, which has also been referred to in the Komape and the Kate cases, that it doesn't serve as a deterrent. There's no evidence put up by the applicants that it serves as a deterrent for the future conduct of the municipality. That's not to say that we're in the habit of repeating what we've done here, but punish the municipality.
You've already done it in Peko. Don't forget about that one. So you see, Mr. Georgiadis, you cite the Ackerman J judgment. That is correct, but Ekurhuleni J seems to suggest in his lone dissent, and I accept it's a lone dissent, that there is possibility for deterrence in these kind of matters. And I'm just wondering aloud, please, this is not my position. I'm wondering aloud, and I want you to engage me on my loud thoughts. I'm wondering aloud whether the time hasn't come that one should, in an instance like this, say to the municipality and all other organs of state that these rights in the Constitution are not empty rights. You know, Mr. Georgiadis, some of these applicants have already passed on. They'll never see the houses they were entitled to. It's a very sad reminder of the emptiness of socioeconomic rights in the Constitution, that people will never see the fruit of those rights. It's the same thing that happened to Ms. Irene Grootboom. She died without ever getting a house. Now we've moved on from there. Surely the time has come where a municipality like Ekurhuleni must be shown that court orders must be respected, that the rights in the Constitution must be respected, that they can't just be empty, valueless rights on a piece of paper that is meaningless. Where do we go if the rule of law is disregarded like this?
Justice Majid, that would be right if we weren't offering any accommodation at all. If in the Kate judgment, the Department of Social Security, or whatever the correct term is, didn't offer any explanation of why it didn't pay Mrs. Kate her benefits, her disability benefit. Her pleas just fell on deaf ears. But in this case, one must have regard to the conduct of the municipality post the order of Thupetji. And that was a genuine attempt to house the applicants, if not in flats, certainly in houses in Esalen Park and in Palm Ridge. And for that, we shouldn't be punished. Because once we get into the arguments of it's about time to teach them a lesson, then we're really in the realms of punishment and the punishing effect of such an order. That's my submission.
But why shouldn't we be there, Mr. Georgiadis? If we look at the history of the matter, the applicants had their applications for subsidies approved as long time ago.
Yes.
Houses were built.
Yes.
Instead of them being given possession of those houses,
yes,
other people occupied those houses. The fault was that of the municipality. why shouldn't really we say the municipality did not respect and uphold the Constitution?
We can say that the municipality didn't between 1998 and the date of the order made by Thupetji. But once the order is made by Thupetji, that right is vindicated. Then all that remains is to consider what's to be done after the order of Thupetji and the non-compliance. And it seems to be that the applicants want constitutional damages as a form of compensation when there's already accommodation available to them by flats or whatever it is. What they do in the correspondence, and this is why the correspondence is essential for the court to look at, what they do is they set us up for constitutional damages all along. They say, we don't want these houses because you haven't given us the specifications. We don't want these houses unless we get our shacks as well. When we acquiesce to all of that, they still don't want to negotiate. They still don't want to engage. In fact, their last letter tells us they don't want to meet us. They don't want to engage with us at all. And now we face a claim of constitutional damages of, to date, will be 15 million rand. Goodness knows what it'll be by 2024 when the houses are built.
But if the municipality carried out Thupetji's order, we wouldn't be here today.
Correct. Correct.
And the offer that has been made, it doesn't comply with Thupetji's order. We're now having the issue of flats when we know that what was ordered in the context of what the applicants had lost in the first place. There had been allocated subsidies. They had been earmarked for freestanding houses. Those houses were built, but instead other people occupied them. So the whole picture must be looked at when we're determining what to do with the municipality. It may well be that it's a question of semantics to say it's constitutional damages, but why shouldn't this court show its displeasure to the conduct of the municipality in not upholding the Constitution over a long period of time against poor and vulnerable people?
The Justice Jafta, the order that was made by Thupetji places, and I think one of the justices made the point earlier, it's actually a higher, it's a higher standard than the right in the Constitution. The reason why I say that is that once you offer the residents flats, then their right is alleviated, then their right is met because they've got a roof over their heads. But it's correct that Thupetji's judgment doesn't, or her order, doesn't comply with, we don't comply with that because it's freestanding houses. So in that sense, the Thupetji order is much higher than what the right is in terms of the section 26 of the Constitution. But from the time that they're claiming damages, which is the 1st of July 2019 to date, we've offered them flats. They haven't, and in that respect, we meet the right. We meet the right in terms of section 26, although we don't meet the court order, I accept that.
In count, oh, so sorry, are you done, my
yes,
brother?
I'm done.
Oh, thank you. In countering what you referred to as an amount fixed through a desktop exercise, the 5,000 Rand, you said that an appropriate amount would be an amount that would approximate to getting houses of that same quality in the open market, that is for rental, that is. Do your clients, or does the municipality make that averment in its answering affidavits before the High Court?
In the answering affidavit, we make the point that the amount is not properly computed, yes. We say that it's a guesstimate taken off the internet.
But do you say why? Because the applicants explain why they have used the figure they have used and how they get to that figure. So my point is, besides just saying what you've said now, does the municipality go to the extent of saying that in our view as the municipality, this is what a reasonable figure would be? Does the municipality do that?
No, we don't do that, Justice Madlanga. What we do say is that they cast the net wide. They say it's 5,000 Rand per month, which is a house on the open market in Tembisa. And they hope, in the hope that the court will give them that amount. But if they don't get, but as my learned friend says, if we don't get that amount, then we'll take whatever other amount the court gives us. And that's left to, that's something that should be, with respect, in our submission, be left to a trial court to determine. What is the level of damages from the period of from the period in which we offer them the flats? They say, well, it's 80% or 20% less. Where do they get that figure from? It's just a thumbsuck. There's no, what they do is they come to court and say, give us damages, give us something. They've suffered no patrimonial loss. There's no hole in the pocket, so to speak. What they're saying is, if we did have houses on the open market from the time that the order was made, they would cost 5,000 Rand per month. Not we intend to take houses and pay 5,000 Rand a month, therefore we need the amount. They want it as damages. It's sort of a solatium to alleviate their plight, so to speak. It's a question of enriching them at the expense of the fiscus, where there's scarce resources, but I've already made that submission.
Mr. Judge, I was just reminded by Justice Jafta's questioning about something that I wanted to raise that completely slipped my mind, and it's this, it's important. He raised with you the fact that because the municipality didn't comply with the Thupetji order, we are in the position where we are now. But I wanted to go back a little further and say, just remind me again that, or confirm with me that the reason why this problem occurred was because of a system that the municipality, in their wisdom, looks more like the lack of it, imposed, which is the dummy number system. That system works like this. If there's a plot number 123 in Tembisa, that plot gets allocated to me, it gets allocated to Justice Jafta, it gets allocated to Justice Kampepe, and so on. We are about 4 or 5 who will get allocated that same plot, with the idea that only one of them will get it. Do I understand the system correct? Because that is how it's explained in the applicant's papers and in their submissions. Is that the system? Dummy number system?
The dummy number system is, as I understood it, and what the case that we made before Thupetji was that you double up on the numbers. Yes,
yes. You have more than one beneficiary allocated to one particular plot. Now, I've never heard of a system like that. It seems to me as a layperson that that system is open to abuse, firstly, and secondly, it's open to disastrous consequences.
I accept that, Justice Majid.
So the whole thing came about, and that the acting HFD of Human Settlements conceded. There was abuse of the system. There was, in fact, corruption, all because of the municipality implementing a system that, with great respect, does not make sense at all. Not even to a person like me. And that lent itself to a situation where these people never got their houses. The applicants, some almost 20 years down the line now, they still don't have houses. More than 20 years, in fact.
Justice Majid,
is that not a case for constitutional damages coupled with supervisory orders, Mr. Jodialis?
No, with respect, the applicants don't make that case out. They don't make out a case that they should be given constitutional damages because of what happened to the
No. That's you must understand me. All I'm saying is they've been deprived of this since the late 1990s, early 2000s. Their rights vested. Everybody accepts. They accept. You accept. And I think, for speaking for myself, I accept that right vested. It could not be varied, as Bason J said. It could not be taken away, as she correctly says. Once it had vested on 1 July 2019, we all accept that. All I'm saying is, the deprivation didn't occur on 1 July 2019. The deprivation occurred from the time that this dummy number system was set up, and it allowed other people to occupy the houses that they were supposed to get.
Yeah, I accept that, Justice Majid, but they're not claiming damages for that period.
I know, we know. All I'm saying is that the right vested in 1 July 2019, but the deprivation.
Sorry, Justice Majid, you muted.
That length of deprivation must weigh heavily when we decide on whether the infringement of this right warrants interference by way of constitutional damages.
Well, that was something that Justice Tefo had in mind when she granted the order. And once the right is vindicated by way of a court order, you shouldn't take that into account as far back as that in my submission. But that reminds me of another submission that perhaps I failed to make. The issue, they claim rental for the period in which they're not housed. When they're housed in flats, where the applicants are housed in flats, they shouldn't have any claim for rental whatsoever because they're now housed. They shouldn't have to claim for rental at all. So if the court's going to grant any constitutional damages, and I don't submit that the court should, it should only grant them for the period 1 July 2019 to date, or to the date that they take the flats. But that's that's the submission. It slipped my mind.
By the way, you got that wrong. Mr. Wilson, as I understood him, didn't say the reduction must be 20%. He said the reduction must be 80%. Once they are in flats, the reduction must be 80%.
I accept that. That's fine. Can I just take an instruction on a further submission, unless there's any other questions? Perhaps I'm left out. Is there any other submissions that we can make?
You were muted, Mr. Georgiadis. You were muted.
I'm sorry. I muted myself in order to take instructions. I've taken instructions now. I don't, unless there's any other questions from the bench, I don't have any.
Thank you, Mr. Georgiadis. Mr. Wilson.
Thank you, Chief Justice. I would like to make 5 submissions in reply. The first relates to the allegation that the applicants have been unreasonable. The application was quite, the allegation that we've been unreasonable was fairly scattershot and vague. But there are 2 facts that I can discern from Mr. Georgiadis' argument, which are the allegation that we've broken off engagement and the allegation that we rejected the temporary accommodation proposal, that I really do think need dealing with because they're not justified on the record. The second point that I want to make in reply relates to whether the issue of houses or flats was before Thupetji. I shall take you to the relevant references on the record for that. Thirdly, I'd like to deal with something that Justice Theron raised with me in my opening address, and in relation to which I've subsequently taken instructions. That relates to the value of the subsidy as it was in the late 1990s and the value of the subsidy as it is now. I just want to refer the court to points on the record that may be of assistance in determining those values and understanding what the subsidies mean. Then I wanted to make a few miscellaneous submissions relating to 1 or 2 points made by my learned friend relating to the punitive or compensatory purpose of constitutional damages and the nature of the quantum that was argued for in the papers before Basonje. The applicants, I am constrained to say, object in the strongest possible terms to the unwarranted language in which their conduct has been described by counsel for the respondents in this court. We've been called unreasonable. We've been characterized as being after a windfall. We've been characterized as snatching at a bargain. There is no dispute before this court that the applicants are desperately poor people living in shacks that want one thing and one thing alone above anything else. And that is a house that complies with the order of Tier 4J. In these circumstances, where so much of the respondents' delinquency is admitted by my learned friend, it is with respect grossly inappropriate to use those words in relation to poor and vulnerable people that seek no more than the vindication of their rights. I can do no better in response to some of those epithets that have been slung at the applicants than the strenuous and forensic examination to which Justice Majid subjected my learned friend. And I won't repeat anything that Justice Majid has changed, that Justice Majid has put to Mr. Georgiadis. But my clients don't have a voice in this court. I have a voice on their behalf. And I know that they would want me to object to the characterization of them as snatching at a bargain and going after a windfall. It's simply, with respect, not appropriate, and the allegation should be withdrawn. Where the allegation of unreasonableness appears to be grounded in some sort of factual allegation, and outside what was debated between my learned friend and Justice Majid, there appear to be two bases. The first is that, according to my learned friend, we rejected the temporary accommodation proposal. Simply not true on the papers. We, in fact, proposed the temporary accommodation be provided in flats, pending the provision of houses at Esalen Park. It was our idea. We say that on the record, and it's not denied. We say that on the application to introduce new evidence, and it's not denied. I accept, Justice Majid, that it's not really important whose idea it was, but in circumstances where we are accused of being grasping and unreasonable, it's important, with respect, that we simply point this out, because this fact is entirely inconsistent with the unacceptable way that we've been characterized by the learned friend. If I can take the court to paragraphs, page 64 of the additional document bundle. There, my attorney, Ms. Zondo, who also, I think, deserves a degree of vindication for the way that she's been described, or the way she's been described as the attorney handling this matter, tells you there that the idea of being provided temporary accommodation in flats pending houses at Esalen Park occurred to her on receipt of the respondent's main opposing affidavit in this matter. She noted the possibility, she says, paragraph 29 of the affidavit there set out, alluded to in paragraph 63.3 of the main answering affidavit in this court. The possibility was that temporary accommodation will be made available in flats pending compliance with the court order. It's important to accept that in the answering affidavit, this was a possibility in relation to which there was no current plan, there was no specificity, there was nothing. I think from memory, it wasn't even a proposal that could actually be straightly made in the answering affidavit. Ms. Zondo seized on it and sought to develop it. Paragraph 30, I sought to engage with the respondents on that possibility. The idea was to negotiate a firm and enforceable timetable for compliance with the court order, again, not what had been offered, and to obtain some sort of interim benefit for the applicants. In the event that constitutional damages are not awarded and lengthy contempt court proceedings become necessary to enforce the order. These negotiations were pursued without prejudice to the applicant's claims for constitutional damages. This is consistent with the general rule that negotiations in good faith to settle a matter or any part of it are privileged. We're not too worried about the privilege part, although we do make certain points in the affidavit about the improper disclosure of without prejudice letters, but that's not what we want to emphasize here. Far from rejecting temporary accommodation in flats, it was in fact Ms. Zondo's initiative in response to a 1 or 2 liner in the main answering affidavit in this court that sought to develop the proposal into something that was appropriate and workable. As is not in dispute between the parties, that then developed into a proposal. The respondents call it an in-principle agreement. It was a proposal that we take occupation of flats at Tembisa extension 25, and that by the middle of this year, and that houses in Esalen Park are then provided by the middle of next year. We then didn't quibble over specifications. What we said was, we're not sure that this isn't just going to be another promise that you're not going to fulfill. Again, Justice Madgett put this to my learned friend, and I won't make too much hay out of it. But the specifications wasn't us pettifogging, it wasn't us being difficult, it was shows you're serious. Of course, we were never shown that they were serious, because in the latest set of correspondence put before this court, they go, oh, well, hang on, we didn't really mean it. You're not going to get houses at Esalen Park in the middle of 2022. It was in response to that that we said what we said at page 168 of the papers. There I'm reading from paragraph 15, paragraph 15 of the letter there annexed. It is not acceptable to our clients that they will have to wait at least another 4 years for the order of Tier 4J to be fulfilled. It is not acceptable to our clients that your client is then incapable of even naming a date. My learned friend seems to pour scorn on that, but it's less than the least they can do. Tell us when, at least. Incapable of even naming a date by which it will comply with that order. It is not acceptable to our clients that any offer of compliance with that order, with the order that your client makes, remains conditional on your client allocating a budget to perform its court-ordered obligation, something at least 1 or 2 members of the court have pointed out has never been done before and should have been done several years ago. It is not acceptable to our clients that it is not acceptable to our clients that your clients are not willing to do anything to compensate them for the inordinate delays that they've already endured. If any of these things change, any one of those things change, then we are more than willing to meet with you to discuss compliance with the order of Tier 4J in a timely manner. If your client has any other proposals that it would like our clients to consider, we will place them before our clients. That's not breaking off negotiations. It's not being unreasonable. It's pointing out that as Justice Madgett said, I believe more than once to my learned friend, it's not us that keep changing the goalposts, it's them. And even after all of that, even after trying over and over again to make our position crystal clear, say, look, we don't know whether you're serious about this, so we want more specifications and we want dates. Their answer is, well, we're actually not serious about it, so you can't have any dates. To characterize us as saying, well, we don't want to meet over any of the proposals that you've made that aren't attached to dates and aren't enforceable. But if you have any other proposals, we'll meet with you. To characterize that as breaking off engagements is with respect false. And again, it caricatures the applicants as unreasonable and grasping in a way that is respectfully just completely inappropriate. It's a very great shame that the learned friend's argument took that approach. And obviously on facts, the facts that my learned friend wants you to introduce and I want you to keep out, it's completely unjustified. We identified something in their pleadings. We said, let's talk about that. We developed it to the point where we said, temporary accommodation in the middle of this year, permanent accommodation in the middle of next year, but please just give us some more detail. Please have a budget. Please have some specifications. Please have a date. They then say, well, you can maybe have some specifications, although they're just general specifications in the National Housing Code. But you can't have a budget and you can't have a date. To characterize us and not them as unreasonable in changing the goalposts in those circumstances is, with respect, lacking in any connection to the objective facts. I want to now deal with the question of whether the difference between flats and houses was before Justice Tim. We accept that there wasn't a dispute between flats. There wasn't a dispute before Tim. I'm sorry, Chief Justice.
As you do, know that you're left with 2.5 minutes.
I will do my best. I have to say, Chief Justice, you're quite right. I haven't been interrupted. I just thought it was very important to make the submission I just did. Maybe I got a touch. Maybe I went on a touch too long. But very quickly, if I can give the court following references. Page 235 of the record, paragraph 41. This is the answer, one of the two answering affidavits that the respondents were permitted to file before Tier 4J. The third sentence of paragraph 41 at the bottom of the bottom of the page says, the respondents have already undertaken to build houses in Tembisa Extension 25 as set out in the answering affidavit. Paragraph 42 on page 236 thereafter. The applicants are not in bureaucratic limbo. It may be that they were required to wait for some time to acquire a house and a service stand. This does not mean they will never get a house. By 2021, all the applicants will be housed in Tembisa Extension 25. The reason there wasn't a dispute about whether the applicant should be given flats or houses before Tier 4J is because the content of the undertaking given to Tier 4J on the papers was that there would be a stand and there would be a house. So to suggest that there was all this horrible confusion about whether or not the applicants would accept flats is, with respect, not connected to the objective facts as they appear on the record. The municipality could have been under no misapprehension about whether or not it required houses or flats to comply with Tier 4J's order, because Tier 4J's order was made on undertakings it gave in its answering affidavit. Justice Mhlanta, I believe, pointed to paragraph 1.1 and 1.2 of the order of Tier 4J. I simply wish to make this point. Paragraph 1.1 obviously says, as Justice Mhlanta says, that the residents need to be provided with a house and not a flat. But look at the obligation in paragraph 1.2. The obligation there is to register the residents as the title holders of their respective urban by the 31st of December 2019. Register as the title holders of their respective urban. Is there any possible interpretation of that part of the order that would suggest that it's consistent with the provision of flats? We would submit not. What was required was land and a house. Each person gets a house, each person gets an urban that it stands on. The reason why there was no controversy, as I say, is because the municipality gave a clear undertaking to provide houses and land to each of the applicants. And I want to just give two quick references in relation to the value of housing subsidies. The first is on the record at page 141. I took Justice Turon there in my opening address. It was a housing subsidy application detail that showed that each of the residents was initially awarded 15,000 Rand. What you will see there is that it's not clear from the detail provided there whether the 15,000 Rand was meant to construct the house or to buy the house, to buy the land and construct the house on it. I took an instruction from my attorney through Mr. Voss during the adjournment. And the situation appears to be that the housing subsidy at the time may well have been just to construct the house. The 15,000 Rand may just have been about the construction of the house, and the land had already been purchased using another part of the subsidy. So what I just want to say is that when I said 45,000 Rand, which turned out to be wrong, and then I corrected myself to 15,000 Rand, I'm not absolutely sure that 15,000 Rand is right either, precisely because that may be too low. There may be a portion of the subsidy which was about the purchase of the house, purchase of the land. Now, of course, that's relevant to the determination of quantum if this court decides to do it differently to the way we have proposed it be done. And I thought it was appropriate in good faith to bring that to the court's attention. The second reference is page 113 of the new bundle. We say that we don't think you should admit the new bundle, but if you're minded to admit the new bundle, page 113 shows the housing subsidy figures as they are now. The top line, the top row of that chart is effectively the subsidy that the applicants or anybody similarly situated would benefit from now, divided up into the various purposes that parts of the subsidy are used for. Something about project payment, there's something about construction there. It essentially slices up the subsidy and tells you where it goes. That might be something appropriate for this court to have regard to. Down to my final two submissions. My learned friend,
Mr. Wilson, how much more time will you need? Your time is up.
2 minutes maximum.
Yeah, please.
If my learned friend is right about the punitive impact of constitutional damages, then everybody who ever has to pay any money for anything is being punished. That's the bottom line there. Effectively, what he said is anything that impacted on the municipality's budget would per se be punitive. That leads to the point that any payment of money is per se a punitive measure, or any order to pay money is per se a punitive measure. That obviously needs to be rejected. It's on its face without any merit whatsoever. Finally, I want to reiterate the applicant's position. The Tier 4J order is the content of the right to housing in this case. It's not higher, it's not lower, it's the same thing, because it gives effect to what the applicants would have got had their subsidies been spent and allocated properly, and had the houses been allocated properly in 1998 or shortly thereafter. So the contention that Tier 4J went off on a frolic of her own and gave the applicants more than the Constitution entitles them to is simply wrong. It gives effect to precisely what the constitutional legislation that gives effect to the Constitution itself would have given the applicants 20 years ago. The order and the right are all of a piece. We ask that the application for leave to appeal be granted. We ask that the order sought in our heads of argument at paragraph 134, I believe, be granted. And we ask that the respondents be ordered to pay the applicant's costs, including the costs of two counsel. I'm very grateful for the court's indulgence, Chief Justice. Unless there's anything else, those are our submissions.
Thank you, Mr. Wilson. Judgment is reserved and court adjourns.
As the court pleases.
As the court pleases.
Today's proceedings have concluded. The host will now terminate the meeting.